What the IA for? Ah. But are you the applicant? Okay, the IA is filed by the uh, appellant. Yeah. So, I then counsel for and so you're the opposite party in the IA. Okay. Then it counsel for the opposite party slash respondent has paid for adjournment of the matter with the consent from the other side. In view of the above, let's after Jones. It is after 4 weeks. But with the consent from the, so you're the respondent, so see, they have agreed. Let us speak this in this matter, as if they come to this matter. Okay, let's see. We'll make it 3 weeks. So let's see if the AG will be available then, unless there's a fixed date or something. Mention this date on behalf of the learned AG for adjournment of the matter, which is not objected by the Mr. D. Pandit, learned counsel for the petition. In view of the above, this after 3 weeks.
Item number 1.
Yes. Notice was served? Yes, Your Honor. Yes, Your Honor. You'll have to file the affidavit, the respondents concerning this. That's what? Rampur Reserve Forest.
Respondent number, mana definition of the respondent number 1 may not be required, mana. Because the respondent number 1 is the performer respondent only.
Okay, who is the respondent number 1, who's the counsel? Anyway, Miss One Singhi, learned counsel for the petitioner is present along with Chato learning DSGI for respondent number 1. And Mr. RH Mama learning for respondent number 2. The learned counsel for respondent number 1 has prayed for further time for the independent. Okay, so here this thing, it appears that we are supposed to obtain instructions, notice not true. So anyway, for further time to get instructions, we'll make it. I'll wait for further time to get instructions. Yeah, after, how long will you take? 2 weeks?
3 weeks.
Just after.
Item number 2.
Page number? Eight. After second, even order. SIC out SIC what accordingly second Something is happening. PR is being processed.
Again.
He's withdrawn and where's it? Where's it parked? Where's the money parked? They kept somewhere. But withdrawn by who?
From what you are saying. Sanction is there. DPR yet to be approved. You saw us withdrawal of the money, payment and withdrawal.
When you said it's the officer, where's the this thing showing the account of the officer where the money has been taken? You're making a very wild. Everyone. Just like that, yeah.
That is
Just
there,
a
nothing
presumption.
remain.
But you are who? You are who? So if it's restricted work, then so who are you to make those questions? You are who? Are you an NGO or? Maybe it's still on its way and it's going to happen. DPR is being prepared. Withdrawn by who? Some specific person, something. Apprehension. Because you find engagement with specific, you just have some apprehension in the air that something is happening. Money has been sanctioned and maybe steps are being taken, but they detail you being a activist. Maybe all the information is not required to be given to you. Isn't it? So at this stage, I think maybe if some instructions are listened into this matter, you receive some instructions. Because, so that maybe he can pay the apprehensions the next day that this is where the money is. Yes, then we don't have to proceed from. And the government feels that an activist should not know everything in the state. Because there's no clear allegation that it has been misappropriated. But you have some apprehension. Okay, so to answer to your apprehensions, maybe some instructions you can see. And then if required, if not satisfied, then we issue.
Yes, Mr. Advocate General,
Uh,
it's a very serious allegation. Why you are sitting behind?
Cannot be a gymkhana where anyone will come, they'll build up their case.
No, you have already approved for preliminary inquiry, page 102. Way back in 2024. Page 102.
I was
At least-
listening, even the theory is not approved.
No, but then once you have approval for, given the approval for preliminary inquiry, there must be something.
So that part, my lord, I can seek instruction.
Yeah.
What happened to that preliminary inquiry?
this is addressed to the SP and made by the Undersecretary Vigilance Department.
Yes, me.
Okay, heard Mr. Run Counsel for the petitioner who has filed the extent public express litigation on behalf of a group of citizens said to be activists who are concerned regarding the alleged huge misappropriation of public funds with regards to a project being implemented in the name of watershed development component of Pradhan Mantri Shikshi Sinchai Yojana. Within brackets, WDC PMKSK 2.0. Under the said scheme, the government of Arunachal Pradesh was to acquire 14915 hectares of land with an estimated cost of development of rupees 40865.20 lakhs. Accordingly, the government of India had sanctioned the amount of the central care amounting to, where's that? Page? Maybe it's 66? No. Is it that page 66? Central share. Where's that? So is it, the amount is it, that's at page 66, page 66? 45. Okay. Amounting to 36770.58 lakhs make it within brackets, 90%, and state share of rupees 4085.65 lakhs within 62 lakhs within brackets 10%. However, till date, no visible steps have been taken by the state respondents, wherein petitioners had also submitted representations and had also inquired about the matter to RTI. But steps were taken by the petitioners. The Vigilance Department, Government of Arunachal, had also asked the Superintendent of Police, SIC Vigilance, former Civil Secretary, by its letter dated 12 March 2024, indicating its approval for preliminary inquiry into the complaint against the misappropriation of government funds for capital WDC PNKSY to work / project in Arunachal Pradesh. However, according to the petitioners, no proper inquiry has taken place, and they have huge apprehension that the state funds states to be released have been misappropriated by the by some concerned by some officials government officials. In view of the above submission, I find it appropriate that the learned additionally to get instructions in this regard, especially when there is an instruction by the Vigilance Department for conducting a preliminary inquiry regarding the state misappropriation of funds. Yes, the matter after 3 weeks.
Item number 3.
This, so that it council for the petitioner is present along with, Mr. Ibrahim, that, additional. For this purpose, PG has been provided time to get instructions. View of number, this after 3 weeks.
Item number 4 and 5.
May I please? Lordship, I have filed an IA 258/2025 yesterday for issuing of an order restraining the respondent number 3.
So where's the IA? So we'll have to issue notice, the IA, the written objection. Isn't it?
Lordship,
Oh, what's the contents of the IA?
yes, Lordship, the contention of the IA is that order dated 29/2/2023 there is a order passed by this honorable court that the instant writ petition is hereby provided that any action taken by the respondent authority pursuant to the various office orders, so cause notice, and summon issued by the vice chancellor of the petitioner university shall be subject to the final outcome of the present writ petition. Lordship, here the petitioner is the private university. Lordship, the petitioner is challenging section 8 of the Arunachal Pradesh Private Educational Institution Regulatory Commission Act 2017, which keeps mandates for 1% of collection of total students' fees received per year by the private educational institution, including university. Being agreed with this act,
Percent.
yes, Lordship, we have filed this writ petition, and there is a clear direction that it will be, this writ petition has been already admitted, and there is a direction not to comply with this act.
Okay, that
But-
challenge part.
Yes, yes.
1%.
Yes.
So what is the IA for?
IA is that, Lordship, again on 9/2/2020, sorry, 26/8/2025. The respondent number 3, they have conducted a meeting, and in the meeting, they have again directed the petitioner for deposits of 1% of the student's fee.
So is that in the same writ petition?
Yes, Lordship.
That's also mentioned in the writ petition.
Yes, yes.
So in the writ petition, this has not been stayed. Say,
The prayer was rejected, my lord.
prayer was rejected. So if the prayer was already rejected, why, how can you file a fresh IA?
The Lordship,
You'll have to deal against the rejection.
Lordship, there is a direction
Uh,
dated 9/2/2023. May kindly peruse page number 33 of my IA. Yes,
okay.
yes, page 40. This is the operating portion.
Then what's the other IA?
Yeah.
259?
Ye-
Okay, but same the same subject matter? Yes. It shall be subject to the final outcome,
Yes,
in subsequent orders.
yes.
So because of that, there is an order.
Yes, despite of this order, page number 43, Lordship of my IA. On dated 9/9/2025, the private respondent number 3, they have conducted a meeting. And in the meeting, they have again passed an order for deposit of 1% fee. Page number 43 of my IA.
Just read page 40.
Lordship. Lordship.
Page 40.
Yes. This is the order.
First para, fourth line, whereof the considered view.
I think the IA has been answered.
Pursuant to the various office order,
No, before that.
The first line, start from the first line of.
Yes,
40.
we are of the considered view that no restraint order in the attending facts and circumstances of the case at hand can be passed against the respondent authority, restraining them from acting in furtherance of Section 810 of the Arunachal Pradesh Private Educational Institution Regulatory Commission Act 2017. That's it.
So. Accordingly, any action, that is been pursuant to the summons and other notices, subject to outcome of the final decision of the writ petition. That's it. Correct. You go for disposal of the writ petition rather than this IA.
Or if you're unhappy with this order,
Yeah.
one notice. Or maybe we to reconsider. It's already been decided.
That's it.
Then how can you press? I mean, this court cannot again say in the form of an IA. So, take time. Wait, I-
Section 8A of the Act mandates every private educational institution and university to deposit 1% fee.
That what the petition is all about.
Yes.
Then,
A very similar provision was enacted and the very same act was enacted by Himachal Pradesh in 2010. This is an act of 2017. Now, in that act also, there is section 8A, which is exactly same to the 8A of the act of 2017. That act, or I'll say the constitutional validity of that act was challenged to the Himachal Pradesh. In my IA, there is an order of the division bench passed by the Himachal Pradesh High Court, where the act was declared constitutionally invalid and held ultra vires the constitution.
but are we bounded by the division bench of?
Your Lordship, the question which this more honorable court has been requested to decide is whether the state legislature of Arunachal Pradesh has the legislative competence to enact an act, the subject matter of which squarely falls under 1966 of the Union List. And that moot question has already been decided.
So that's just the connected writ petition where you're challenging the 1% of. Now, in the instant IA, okay, there's an already, since there are two writ petitions,
Your Lordship,
so they're a common order, I presume it must be a common
Yes, yes.
order, isn't it?
That's
So now
common
since
order.
it's a common order,
It was my
and in the common order says that any orders, subsequent orders, whatever it's passed, they allow this court will not interfere, but it will be subject to the outcome of the writ petition. Now, your IA, in your IA, you're saying that exactly similar circumstances had arisen, the Himachal. Okay. So now you're trying to impress upon this court that the decision or what the outcome of the case in the Himachal Pradesh should also be the extent case, isn't it?
No, Your Lordship.
Then,
There is a subsequent happening event.
okay, then they went
That
to the
order,
apex
yes,
court.
that
They
order
went to the
made
apex
by
court.
the state of Himachal Pradesh against the decision of the Himachal Pradesh High Court. They went to the Supreme Court, and that matter is pending. And any observation or decision of the Supreme Court will have a bearing on this case.
So we'll keep it pending in the meantime then.
Yes, unitship, but how it will,
But don't press your IA yet because there's already an order in the writ
yes,
petition.
that,
Ah.
as an officer of
Yeah,
the court, it's
yeah.
my duty to intimate to the bench that there is a similar matter pending before the Honorable Supreme Court. However,
Till then, both the IGS and the writ petition also, we'll have to wait. If you're saying it's exactly the same, but you have to impress upon us that it is exactly the same.
yes, your leadership, for that,
Ah,
your leadership may have my ID,
ah.
page number 23.
So why have you filed the IA?
Yes,
Why have you filed the IA when in the writ petition itself, you can mention.
we have
that
not,
the matter-
Your Worship, subsequent to filing of the writ petition,
Oh.
these minutes of a meeting was convened,
Even then. Okay, anyway, so page what?
page 20. Of the item. This is the
Himachal.
Himachal Pradesh Act,
Uh,
section 8A. It is in the exactly same terms.
okay, what, 1%, whatever.
Exactly same term.
Uh.
And then on page number 26 is the judgment passed by Himachal Pradesh High Court,
Okay, which sets aside the 1%.
with sets aside the entire act itself.
Okay,
the
but,
entire act
but
was
we are
otherwise set-
concerned with the 1%.
Right.
So 1% is also set aside.
Yes, that's also said.
So now it's gone to the,
Honorable Supreme Court, the order is on page number
matters
55.
pending, page 55.
That is the order of Honorable Supreme.
The status quo ante also.
Status quo.
So
Yes.
then,
Then
It's
there
still
is
operating.
one more document, my lord. That is
It's still operating. It's still,
Right, right,
it's,
but
it's still operating.
I totally bow down to the what is falling from my lord. But one aspect on page number 56, there is a reply to an RTA application that pursuant to the order passed by the Honorable Supreme Court, the status quo ante order, whether the commission, Himachal Pradesh Commission, Regulatory Commission, has accepted those donations of 3 or 1% or not. And in addition, the first question which has been put to the commission in Himachal Pradesh, Mary, please provide me the information about the collected value from private universities from 2012 to year 2022. Leadership, the commission in Himachal Pradesh, after the Supreme Court order, has not collected it.
It's up to them. But
Anyway,
actually,
it's not-
they don't-
basically, the IAs, it is been filed while there was already an order in the WPC.
Right.
So if there's already an order in the WPC, then you cannot file a subsequent IA, okay, which is against, it appears, okay, that which is not in consonance with the order in the WPC. So if you're unhappy with the order in the WPC that has already been issued, then you can go on appeal or in the WPC to maybe review, reconsider this order, but not in the form of a appeal.
There is only one difference in addition. No interim order has been passed in my, the interim order which my
But I thought
has
it's
read,
taken up together, common order.
that order was passed subsequently filed this writ petition.
But when the whole matter is the same, then, and it's been listed together, isn't it? What the WPCs,
Right.
analogous matters.
My IA, as a matter of fact, it was still pending. Such order has been passed. The order was passed in their,
No, it's not an IA, it's WPC.
my IA.
But let's see the WPC,
Yes.
the order in the WPC, both the matters taken up. So automatically, since it's a different university, or is it
So the
concerning the same
yes,
same act, then
agreed by the same provision.
then it is one more or less the same. We cannot have a different order. Isn't it? So we'll dismiss both the IAs at this stage.
You should at least it may be kept pending till the matter is decided by the court, so that we can at least have. That is why
I'm not getting your point as to regarding the IA, when in the WPC covering the required section of the act, there's already an order.
in the IA we are challenging the subsequent direction as well. So in case
Where's the subsequent direction? What
subsequent direction by the commission to us. Let's say there was some summons and notices issued prior to filing of the writ petition. Subsequent filing the writ petition, there are fresh orders. We are also challenging those fresh orders. In conclusion, if your leadership, if the bench would be of the opinion that this is an
No, but
I
the
think
fresh
everything will
orders, the WPC, if I'm not mistaken, in the order of this code in the WPC, it says that orders, there is no bar for the university or the state, whatever, the government act or the commission to pass orders. But all those orders
Will
will
be subject
be
to the
subject to the outcome. So subsequently, they have passed those orders.
leadership, then in
But
that
the
case,
WPC takes care of your matter,
leadership in that
very covered.
My
So
only,
you need it, with this much here, IS.
but my another IE for interim relief which was filed on day one is also pending. There is no such order. in my
That, when that comes up.
then a very similar order may be passed that it will be also subject to the outcome. There is no such finding in my case. That is my only question. The order which my learned
Wait,
friend
wait,
is relying
wait,
upon.
yes, yes,
As of
WPC. Okay, so, WPC 177 and WPC 476. So yes, it's 476 and subsequently there is 177.
Right.
So we will, I think we will mention that both the IAs are dismissed and the order in the WPC dated, what is the date? 06. Okay, that order, whichever order, is also applicable in the instant WPC. So, yes, 17, 0902. So
That will be applicable to us. And
Because I passed the order. I think a dictation later, that's the substance of the same. Yes.
Item number 7.
Yes.
IA for contradiction of delay for 407 days. It's a criminal jail appeal. I'm representing the legal aid council.
Okay, this thing, additional PP,
Delay
notice, Villala,
may be con-
but Mr.
JG.
Legal aid counsel for the applicant who has filed the instant application under section 5 of the Limitation Act, 1963 for condonation of a delay of 407 days filing the appeal number 6-2024 against the judgment of order, which the state, the IA mentioned. Such a judgment for which you filed in.
16/6/2023.
Which,
Paragraph 2 of my IA.
against the judgment and order of conviction dated 16/06/2023, passed by the learned session judge, Lower Dipang Valley District, in connection with sessions case arising out of FIR. But the sessions case number you have not given. Not the FIR number, we want the sessions case number, isn't it?
Yes. Yes.
Where have you mentioned that? But yeah, this thing, yeah, IA should be complete, you don't have to search for. When you find the IA, what's that, correct details,
Correct. That I must.
make a correction. Or will accept this. They think with the corrections or with it. How do you make the correct, proper corrections?
Since this is a jail appeal,
But you were the legal aid counsel who has made this, not the, it won't be the convicted who has done this. You are the legal aid counsel, so you are the counsel who must have drafted this.
drafts are coming the jail of
Draft is not made by you, by the jail authority. That's it.
The legal aid counsel. We
normally
find that these IAs and applications filed by legal aid counsel in American really perfect.
normally they draft
You are not serious. You are equally as a private counsel, you are equally as a responsible.
exactly.
When you are appointed as a legal aid, rather you have in fact more responsibility.
Just make the correction, it's not difficult. File an IO to make the correction, but we don't wait. once we look like this, we'll know, oh, this is like.
But seems serving his conviction in TSU jail, you know, going and coming back is really good.
So this time we'll not take note of that. We'll turn to click on the road and turn. But next time, we have been careful. It was against the,
Let me copy that.
we then the appeal and the appeal should be complete. Session case number 50 in brackets, LDD, close bracket, slash 2021. Under section 302 of the IPC and section 27 within brackets 1 of the Act, wherein the applicant on sentence to undergo
Life imprisonment.
5,000. That has no objection. Days says this is a jail of the. Application or application of 07 days by the connected to the procedure to the same occupation. Very at the applicant para at para 3 and 4 as going to be reason for delay, which we find is not due to any negligence to not motivate applicant, but due to the fact that engage counsel, counsel of that be satisfied which stands out. Then the main appeal on the disposal of filing number 98 by the city. What is a political cost? I think after after orders were passed to the IA, I think this information has to application has to be presented to the application is the disposal of I number 93 of 1955, divided by the paste. But 50 sentence. The whole of PCR.
Item number 8.
It's that. So it's that turn of service respective. What number, what stop the fix.
Item number 10 and 11.
So by making a motion on behalf of Mr. P. Picha. Because he is unaware, this matter will be taken up after following steps.
Your, for the, your amyloiditis or it is. Beginning from, beginning from. Right, check 11, I will give you. Beginning from. Mention is made on behalf of Mr.
P. Picha is the leading.
Visha. Direct counsel for the respondent. For the victim, respondent number 2, that victim for adjournment of the matter since the counsel is not able to appear to his numbers for the case. Counsel for in what then, yes, then, number 10 slash 2023 and this done it, legal aid counsel in criminal appeal number 11 slash 2023 are present and have not objected to the number this after 3 weeks. 4 weeks. Okay. Yes, the presence of sir. That is
Item number 12.
Legal aid counsel, I think you verify the records, trial court records.
but Mr. Garnet counsel has been done the matter since he to verify the documents. So, documents, slash, yes, documents slash, if you observe this after 3 weeks, the presence of BP, addition of BP and Mr. Garnet legal aid counsel for responding number 2.
My senior now. Yes, the trouble.
Motion is made on behalf of. Mr. S. Bhatta.
8-9.
Yes. Ms. Bhatta, learned, Senior Counsel for the petition of for a government of the matter since it not able to update some person of the Mr. You are for the learned, I think we are additionally for the state respondents and not to the objective in the government of the. Is the matter after or on 27, 11, 27, 10. Okay. Uh, 10, 20, 22. Right, wherein an endeavor. The water past and
Your Lordship, I'd like to mention item number 17 and 18. By reading counsel due to medical ground, Subukoy, sir, petitioner, I took the concern of the opposite party too regarding the mention.
the action is on behalf of Mr.
Subukoy, Subukoy, ex-Koya,
Learned Counsel for the
petitioner,
applicant slash for judgment of the matter. The consent from the other side. You cover this after
1 week.
1 week.
May I take offline? Your Lordship, I like mention
1 to 14, yes, contempt.
yes, you got them as a best petition.
Ah,
Here, Your Lordship, the counsel for the petitioner, he reads some conditions that I.
so the mention is made on behalf of who is the counsel?
I'm going to respond, Your Lordship.
Okay.
With his consent only.
Mr. So and so learned counsel for the respondent
Yes, Your Lordship.
has prayed for adjournment of the matter with the consent from the other side.
Yes, Your Lordship.
Three of the above list after
4 weeks.
4 weeks. 12, 13 and 14, isn't it?
Yes.
These matters.
Your Lordship, item number 10, I on behalf of N. Tajay. Your Honor, leading counsel is out of station, so Your Honor, better maybe listed after 3 weeks.
Have
or
you
3 weeks.
taken the consent?
Yes, I have taken consent to both.
Mention is made on behalf of Mr.
Tajay.
Tajay, learned counsel for the petitioner for adjournment of the matter, the consent from the other side. Three of the above list after 3 weeks. Yes. So and so, learned counsel for one number. Has paid for adjournment of the matter, consent. Three of the above, the matter of. This the matter, but this is for hearing. Okay, this the matter after 2 weeks. Okay, after 2 weeks, meanwhile, interim order passed earlier shall continue till the next day. Your body. Mr. So-and-so, learned counsel for the petitioner has paid for adjournment of the matter with consent to the consent. We have never, this down. While interim order passed earlier can continue to the next stage of the step. Have you taken the consent? From the petition. I bound direct counsel for the petitioner is present along with Mr. So direct counsel for respondent, number 4 and 5. So direct counsel for respondents. Great for the time final counter. The above is after 2 weeks.
Your Lordship, I beg to mention item number 24 and 12. And for the petitioner and representing on behalf of Mr. Opada, leading counsel for the petitioner
What happened? Why is it here? Yeah.
is out of station.
His senior has, recently extended. With the,
He's out of station, so he'll be available tomorrow.
yes. So it is.
Can say, but okay, then we can see other.
It's, yes,
Bench, Mr.
We know
We bearing on behalf of Mr. O. Father, that in council for petition as prayed for adjournment of the matter. Which is not objected by Mr. Learned H. Isn't it? That Learned additional AG for the state respondents. Is mentioned about that the council for the petitioner. Tomorrow, that just one seven seven three of them is on.
I would like to mention item number 37. For adjournment, I have taken consent from the other side.
You for the petitioner,
I am for defense. This matter may be listed after 2 weeks.
Mr.
Table the judge.
Current council for the petitioner has prayed for a. Stop it.
Matter.
Item number 3. Is made on behalf of Mr. N. Gardner, the council body. The respondents number 4 and 5, matter 6 will not council. Said we are. Consent taken. It also mentioned that the consent of the petitioners have also been taken. With after 2 weeks, after 3 weeks.
Item number 1.
Please, see. So let me say, this is a matter regarding non-pending, non-pending bids.
Okay, so we were supposed to file an IA.
Yes, your lordship, ladies, I filed the IA number 257 regarding the correction of post item. There was a sample error mistake.
So, who is the counsel for the respondent? Will allow the IA and dispose it of. Mr. Counsel for the applicant. Who has filed the instant application under section 151 of the Code of Civil Procedure, claim for the correction in the /typographical mistake because title of the connected WPC number 159 /2025. Council for the respondent is present and has not made any objection to the correction of the cost value possible. I number 257 of the Stands allowed and this was not on the council for the applicant making the necessary corrections that be connected to 459 of 2020. Yes. So now it's remain the same. Have you made the corrections? Not yet.
When the recent your also I have not, I made it the IA.
So now we have made it in the IA, so you make it in the WPC also. So in the remain WPC, on the disposal of, IA number 257 of 2024, there are, council for the position and to make necessary corrections. Make the correction here.
I'll make it correction because this matter was earlier was listed in the court puja vacation and it is regarding not pending payment of not pending leave. Since for that,
We'll make it listed with the correction. Okay. Because then we'll see, what is the correction required. What required, the listing party was not, arrayed or what is the correction?
it was
You don't mention it in the IA.
instead of your Lord ladyship, it should have been a secretary represented by Union of India. Instead of that, I have typed it as a managing director. So there,
So you make the correction, okay, then notice, we have to go to the correct person. So let's in the next week with that correction and then we'll show notice.
on Monday 27.
Okay, but this bench is not sitting on Monday, but they can go to the other bench. Just on 27, then
Item number 2.
May I plead your lordship?
yes.
Lordship, in the instant matter, I am aggrieved by the impugned order dated 7/5/2025, whereby I was transferred from workshop Karsinga to Tinsukia, Assam. And then your lordship, again, the impugned order dated 30/5/2025, whereby I was released from my previous place of posting, your lordship. Then your lordship, at last, the impugned order dated 7/8/2025, whereby I was given so-called notice to join my new place of posting within 1 week. Here, your lordship, the matter is very simple. Your lordship, I am an executive engineer. Now the department, that is transport department, they have transferred me to such a place where the post for executive engineer, that post does not exist. Until date, the government of Arunachal Pradesh, they have not created any post in Tinsukia, Assam for executive engineer. So your lordship, as per my rank, I'm gazetted officer. And now, as of now, this transport office, which is situated in Tinsukia, Assam, that is only for senior assistant officer. There is no post for executive engineer. Your lordship, accordingly, when my transfer order was issued by the concerned department, I had also made 2 representations to consider that since there is no such post for an executive engineer to be posted in such a place. But your lordship, till now, that 2 representations had not been considered. So I am aggrieved with the actions of the respondent authority. So your lordship, I pray to the honorable court that since it's only in motion stage, so in the meantime, even I have prayed for interim relief. So for the time being, your lordship, that impugned orders may be stayed till the next returnable date, your lordship.
Your first transfer, okay, your main ground is because there's no post in the place where
Yes.
you're transferred. That's it. So you cannot join or what?
Yes, lordship. So there is no post for executive engineer. There is no such post in Tinsukia, Assam. At least your lordship, it's just
Let's see
like
your transfer order. Let's see your transfer order. Take me to lecture what page number.
your lordship, that
You're
is
saying there's no post.
That is page 53, your lordship.
But there is a post of executive engineer, isn't it? So you're going to have a whole additional charge. Look at
That is what your
page
lordship.
53, let's say.
Yes, that is my transfer order.
Uh,
But here, as I said that since I'm an executive engineer and the place where I have been posted as of now, according to this impugned order, there is no such post for executive engineer. There is only highest rank officer is senior assistant officer, your lordship. So senior assistant officer is below in rank than me. Then how can I can be posted in such a place when there is no such
we'll issue a notice that say heard Mr. Yes, your good name, heard Mr.
peace, your lordship?
Student Learned Council for the petitioner who has filed the instant petition arranging his transfer order dated '08, isn't it 2025? On the ground that the petitioner is the executive engineer within brackets auto, close bracket, comma, central, okay, auto, okay, close bracket. And he has been in service and as executive engineer within brackets auto, central workshop, comma, Karsinga Sa. However, he has now been transferred to which place you say?
Tinsukia, Assam lordship. From Karsinga to
And
Donor lordship.
he has been transferred to Tinsukia, Assam by the order. However, there is no existing post of executive engineer within brackets auto at Tinsukia, Assam, and therefore the petitioner is not able to join duty the said transfer place. The petitioner being agreed with the transfer order dated 20/08/2025 as filed today instead petition. Notice the once over. Oh, okay, okay, then any other, this thing? Only to issue just copies of the. This after, 2 weeks,
Lordship,
4 weeks.
lordship, I have an interim prayer, your lordship, till the
after
reasonable
4
date,
weeks.
impugned order may
Meanwhile,
be issued, your lordship.
let me give an order. Meanwhile, as written by the Learned Council.
He has already been released, Your Lordship.
Yes, already.
Yes, Your Lordship. I can state your Lordship.
Okay, then, till the next date, okay. After, this is a matter after, make it 3 weeks, not make it, 3 weeks. The Learned Council for the petitioner has paid for the stay of the, transfer order dated 20/2025. However,
Transfer order is lordship, dated 7/5, your lordship.
No. It's 20 something.
28 is the representation case. Page
Yeah, take to the- Where's your transfer order? Page?
Page 53, your lordship, annexure 8, your lordship. Page 53.
Okay. Yes, paid for the stay of the transfer order dated 07/05/2020. Five. However, the learned government takes up that the petitioner has already been released from this case. By order dated by
30/35/2025.
is that
Page 56, your lordship.
dated 13/5/2025. To enable him to join case of mercy and zonal workshop from Arunachal Pradesh State Transport Services SAP. Stay on the same. 07.
Item number 5,
Obliged, lordship.
I am extremely sorry, my lord. Item number 3 was mentioned by a younger colleague of us. Has not informed me. There is an interim order operating, item number 3. So that interim order may kindly be continued. Item 3,
Interim order passed earlier.
I'm grateful.
item number 5,
This one, readings are completed. It's ready for hearing.
Is readings complete? Learned councils for both the parties are present and subject that readings are. We have the book, is the matter for official hearing. After 1 week? 2 weeks. After 2 weeks.
item number 6,
See, what that matter already,
But today, the regional AG is with us now. And sir is there and I was supposed to place my citations.
citation.
I'll place my citations and the AG then sir will make the.
Anything in the, yes.
So my lord, the first citation which I have submitted yesterday, day for yesterday, was the Aurovoli Foundation. And we have given the list of books on the clean hands. So that judgment I have indicated para 9. That there will be benefit. Okay.
Okay, let's, where are we? The public, where's the, when did you give?
Yeah, I have given that soft
Okay, hard copy of the judgment.
hard copy
I
of the.
thought you were going to give me something else, not what you have already mentioned.
Yes. I am giving the
2025 SCC, that you have
yeah
given.
para 9. That's just reflection, Miller. Press. So
Which one? 2025 SCC online?
yes,
Okay.
paragraph 9,
Ah,
paragraph 10. Paragraph 9 and 10.
Then,
This you have already read out.
no, I'm not reading out, madam, just
Oh, okay.
refreshing. just
Okay,
indicating,
refreshing.
the-
Okay. What does
Then,
it
you know,
say?
there is another judgment. Bipin Chandra Phukan, that copy is very simple. Paragraph 11, sixth line. After withdrawal of the EMD, one cannot maintain, he has no locus, and virtually it is in view of the fact that earlier he has filed writ petition number 95 and withdrawn it, and in the meantime has also withdrawn the EMD and subsequently filed this writ petition number 1111. So therefore, he doesn't have the locus to maintain this case. Now, my lord, next judgment, which I am indicating the paragraph, my lord, I will not read. This Marbinda Express, my lord, 2014. My lord, I'm
You
indicating,
give it to you. Give it a listen.
my lord, this 2014 pre-SSC 760 paragraph 8. It says, on the proposition that submission of a bid tendered
Oh,
in
but
response.
you're reading, but I don't have to copy back and read on the same page.
Already,
So many judgments.
but my lord, I'm indicating the paragraph so that
Okay. Then it's.
just I'm giving the principle on what principle. So paragraph 8 of this Marbinda Judgment Express has held that submission of a bid stroke tender in response to a NIT is only an offer. State are under no obligation to accept. Bidder participating in tender process cannot insist that their bids should be accepted simply because the bid
You
is
just
highest.
give me a just you don't read because reading it, you have to strain our concentration.
Correct.
So just give me the gist, the. When did you give this list? When did you give this list?
Morning normally we give.
You see, they should be ready, they're not ready. Hmm. If not, what we do, okay. You know what's doing here, and then, this is your, and this type of. They give you this. Oh, we have copy.
Correct.
And it's such a long list. What we have seen, the list of judgments is very long. So you don't have to repeat all the.
I'm not-
On one principle, it's okay, one basic judgment,
Correct, that's why,
it's okay.
that's why
So which one? And what is the principle?
he says
Instead of, don't read, just tell me what is the basic.
On-
This,
that Marbinda Express will on the principle that he has participated the bid and insisted that his bid should be considered, which Apex Board has held that it is an offer, state is under no obligation to accept your bid, whether it is highest or the,
Not obligated.
yes, no. The para 8, 2014 PSSC page 760. Now, Milord, I rely on the assessment for 2016, Milord. 2016 for GNT. Page 230,
Yes.
paragraph 10, 13, 14, and 15. Milord, the principle is disqualified person cannot file a writ petition seeking the interference after his bid is rejected. And second principle is that once the work is substantially been done, the writ court should not, in exercise of judicial review, should interfere in this. Because here, my lord, I have already done the work. And then this has come. Then, my lord, this now 2016, my lord, 8 SSC page 6, paragraph 48 and 49, that is central 40. Very you have written wrongly. Anyways, but I just give it. Paragraph 40 and 49. The principle is that
What topics there?
you get it from here. Speed 8 SSC page 6 double. Because Milord, why I'm relying on this prediction that his speed has been rejected.
So you should have given the hard copy to us to do.
But I have the copy, I'll give it.
Be able to read on the same page when we follow each other.
Fine. But for the first time I'm encountering this situation. And yes, here, accommodate. Steve, my lord, kindly note down this citation. My lord,
This is 2022.
yes, I will come. This I will come.
2022, 6 CC 127. Okay.
Well, before this, I have referred to this 2016 ASC base 622 paragraph 48 and 49. Now, Milord, the learned senior counsel, while advancing the argument, have made a point that the BG, Milord, which was submitted, the BG which was submitted by me through HT Enterprises, which is owned by the petitioner himself. Then he says this is not part of the tender conditions. Now, Milord, what had happened? That in the tender condition, Milord, it does not say from which source, from which account you have to give this bank guarantee, Milord. So therefore, Milord, paragraph 948, 49, the central court, it says, decision of the employer must be respected by the courts. And even if the term is essential, the employer has the inherent authority to deviate from it, provided the deviation is made applicable to all. Level playing field has been granted to them as well. So now, my lord is kindly aware, my LG product may not have just I have my copy here. So there are 10.
2022.
Yes.
6 SC.
There are,
Oh.
yes. We find that the inference in contract awarded to the appellant is wholly unwarranted and has caused no loss to public interest. The first seminal line, the meaning which it contains, my lord, is this is purely a contract matter, and the petitioner does not show any public interest. Construction of the road is an essential condition of the development of infrastructure in any state. The learned single bench and division bench of the High Court were exercising power of judicial review to find out whether the decision of the state was manifestly arbitrary or unjust as laid down by this court in Tata Cellular, Union of India, and to act as appellate authority over the decision of the state. This court in Tata Cellular held so and so. Kindly see this paragraph. Well, here, the important to be noted is paragraph 77. Down below, cellular has been quoted. If permits me to read out. The duty of the court is to confine itself to the question of legality. Its concern should be whether a decision-making authority exceeds its power committed an error of law. 3. Committed a breach of the rules of natural justice, reached a decision which no reasonable tribunal would have reached or abused its power. Now, my lord has already screened the facts which was valiantly submitted by the senior counsel other day. But these paragraph 77 of the Tata Cellular, none of the principle laid down has been overcome by the learned senior counsel while presenting the case for the petitioner. So therefore, this is one count where his argument should be rejected. Now, my lord will kindly come to para 11, where those leading judgments have been reiterated. Now, my lord, that paragraph 47 down below, my lord, these are all settled principles. Paragraph 47 is the important for me. The result of this discussion is that the issue of the acceptance or rejectance of a bid or a bidder should be looked at not only from the point of view of the unsuccessful party, but also from the point of view of the employer. Now here, my lord, I'm pausing for a moment and giving my interpretations. Now, level playing field has been given to them. Their bid documents have also been examined. And primarily, my lord, will kindly see the annexure to the rejection of ground. They have provided 4 numbers of the
Yes.
vehicle registration certificate, and these were all provided offline. Now, these days, my lord, the concept of offline system is gone. If you do something, my lord, it will be available in the Vahan itself. So these was not raised. This could not be produced by them on the date of scrutiny of the regulation, thereby entail the rejections. So this is my explanation to that. I am reading again. The result of this discussion is that the issue of the acceptance or rejection of a bid or bidder should be looked at not only from the point of view of the unsuccessful party, but also from the point of view of the employer. Meaning thereby clear, you were given an opportunity, please come online and show your registration certificate is valid or not, which he has not done. So therefore, this is the employer perspective. As held in Ramana Dayaram City, the terms of NIT cannot be ignored because it was mandatory. Whether the terms and condition has been made mandatory, then you must furnish the vehicle details, your insurance, your road permit. But on the day of scrutiny, you could not produce. So therefore, this principle attracts me. As pointed out in Tata Cellular, there must be a judicial restraint in interfering with the administrative actions. Rightly, my lord. If there is an arbitrariness or nullify the exercise of the power by tendering authority in the form of administrative in nature, court might have to refrain. Ordinarily, the soundness of the soundness of the decision taken by the employer ought not to be questioned, but the decision-making process can certainly be subject to judicial review. The soundness of the decision may be questioned if it is irrational or malafide or intended to favor someone or a decision that no responsible authority acting reasonably and in accordance with the relevant law would reach, as held in Jagdish Mandal. Jagdish Mandal, when I was remembering paragraph 22. Again, my lord, 49. Again, looked at from the point of view of the employer, if the court takes over the decision-making function of the employer and make a distinction between essential and non-essential terms contrary to the intention of the employer and thereby rewrite the arrangement, it could lead to all sorts of problems, including the one that we are grappling with. For example, the GTC that we are concerned with specifically states in clause 15.2 that any bid not accompanied by acceptable bid security, EMD, shall be rejected by employer as non-responsive. Sure, I'm posing this line because he could not produce his vehicle registration, whether that was fake or not. Normally, that is the scrutiny they do. but just para 12, I'm referring for one purpose only. That the employer is the author of the tender and their decision must be respected. In African and so, this court held that the owner or employer of a project having authored the tender document is the best person to understand and appreciate its requirement and interpret its document. It was held under so paragraph. In other words, a mere disagreement with decision-making process or the decision of the administrative authority is no reason for a constitutional court to interfere. The threshold of mala fide intention to favor someone or arbitrariness, irrationality or perversity must be made before the constitutional court interferes with the decision-making process or the decision. Well, I am repeatedly making this argument that nothing has been alleged, no mala fide against or the arbitrary action against the tender bill regulation committee has been made the entire petition. Now, para 13, I'm just para 13 also, my lord, will take on board. I'll not read this on the same proposition.
Yes.
It's about the
The
limitations.
same thing. So, no matter by me, not to interfere,
Nothing.
all that. So you have made your point. Can you do that?
I indicate this point. My lord will kindly come to era 29 as well.
29. What is
Before that, my lord, 28.
Para 29?
28 is also very important for me, my lord. These are the reflections of the patina of decisions made by Honorable Apex Court as well as this Honorable Court. It says there cannot be any disagreement to the legal proposition propounded in a patina of decision of this court relied upon by the learned counsel for the response to the effect that the court does not see it as a court appeal in the matter, however, of the check, and it merely reviews the manner in which the decision was made. And the government and its instrumentary must have a freedom of entering into the contract. However, it is equally well settled that the decision of the government instrumentality must be free from arbitrariness and must not be affected by any bias or actuated by bias. So, Milord, this same thing, 2930 also, Milord.
Same principle.
Yes.
Okay.
Now, Milord,
With that,
Tata Cellular, which I was referring, my Lord will find in paragraph 32.
Where Tata?
Tata Cellular. Sorry, my Lord. That's
See, you have all the hard copy with you. We have nothing with us.
so,
it's very difficult to
I'm extremely sorry, my Lord.
Oh,
This para, I read something wrong. Even on paragraph 30.
what?
But shall continue, my Lord. There was a
This is NG projects.
NG project. I misclicked it.
So in NG projects,
Or remember, I am relying only on this paragraphs 10, 11, 12, 13, 14.
that you have given in the notes.
Yes.
That you have read. So
Yes.
just leave it at that.
Yes.
So lots of judgments. You can leave it at that. I think
Yeah.
unless there's some other point.
Now, my Lord,
Oh,
10 SSC 73.
you have the hard copy with you.
This
Right. Or it out or give it a little bit beforehand that they can be ready.
Next time. Page 7.
Not 22.
Yes. Now, the proposition is once your technical bill is rejected, you have no further right to agitate before this court. Para 22, my lord. When the technical bid of the appealant was rejected by the respondent on 6/5/2024 on the ground that it did not comply with the clause 10 of NIT, namely so and so. In other words, important documents, appendix so and so of the sign of the attorney for sign. There was no justification on the part of respondent authority for accepting the technical bid of the respondent, which clearly was not in compliance with the same mandatory rules. So they have not put it. So on one or two things, they were asked to file their affidavit signed by the magistrate. Instead of magistrate, all their affidavits they have signed to the executed to the notary. Once tender condition says that it should be through the magistrate, it must be magistrate. Now here, I rely on paragraph 29, 31, 32, 33, 34, and 35. Tata Cellular, my lord will find it, there are 32 of them. But these are this is my lord. Then 33 also. The 34, my lord, that Jagdish Mandal, which I was referring, paragraph 22. They have not complied with anything. So, my lord, then paragraph 35 is the Vihan India Limited. While observing the government contract granted by the government, body must uphold fairness, equality, and rule of law. So this is already there, and then the central court bill, which I have reiterated in paragraph.
So this judgment covers all the other citations you have mentioned.
Every-
So leave it at that. Good one.
Finally, this thing. He is harping on my weakness, on my defense. But the law is well settled. You must agitate before the court in your litigation of your own merits, but not on
Okay,
the
so
weakness.
give me one citation. Let's leave it at that.
I don't know how to be-
Page what? DNT.
I-
Give me the hard copy.
So therefore, because the sum and substance of my argument. Pressing only on two counts. Number one, I have not approached this honorable court with a clean hands because you have suppressed the material facts by not disclosing that EMD. After the withdrawal of the EMD, you have filed this repetition number 1111, the instant repetition. So therefore, you have lost your locus. You cannot maintain this repetition. And number two, my lord, he has not executed all his affidavit before the magistrate, which is provided in the terms and conditions of the NIT.
Yes, okay, 2008 just cannot rely on the weakness of
Others.
saying, so give it at that. I think the other points you have already
Covered.
mentioned.
So
Covered.
there-
So leave it,
Therefore, Lord, I will not take much time with this judgment for the end of this, my lord. Therefore, my lord, I respectfully pray that kindly take on board my affidavit in opposition, where I have clearly explained that he has alleged that I have not complied with the terms and conditions, NOC and other required documents. But this is already provided in my affidavit in opposition. My lord, kindly take on board my affidavit in
Yes.
opposition to fortify my argument in this matter. So finally, my lord, with greatest respect, this writ petitions deserves to be dismissed with cost. For the reasons that you have come to this court without their clean hands and then wasted the precious judicial time as well as halted the supply of the rice to the people who are required. The people of the on this ground, this nation must.
My lord, in this case, my lord will be submitting a small written argument for that, my lord. Now, in this tender, my lord, the process, it's a supply of both grades, my lord. It's an essential commodity. Now, this was for the period of 2005 to 2007, my lord, for 2 years. Now, my lord, 2005 to 2007. Now, my lord,
What's next? Why not? Yeah.
The tests are based on the term and condition. The term and condition are very strong in a given. Well, in the term and condition, if the EMD is released or taken up, the debt would become impractical. Now, here in the case, it's very much different. As per the submission by the government, 27/7/2025, the EMD was not withdrawn, but it was released as per the term and condition. Now, 111 WPC was filed on 28/2/2005. Yeah, now
He said it was withdrawn, not released. It was not withdrawn, it was.
individual, but potential it was released, not withdrawn. And as per the term and condition, it was
um,
term and condition. Earnest money of these two lakhs only in the form of deposit and all receipt. Fixed deposit receipt in favor of the Deputy Commissioner, Paketesan Christie. The earnest money will be refunded on finalization of the tender. So the authority has released.
they
After
funded you the money.
after completion of the process of the tender. Process of the tender. So releasing of the earnest money cannot defeated the purpose of the petition. Now, whatever ruling which they have quoted and cited is not applicable in this case. Now, why I am telling you that accepted and rejected. In normally, in the tender cases, one is qualified and one is unqualified. But here in the case is different. Case is shortfall. All parties are the contact tenderer, all are having shortfall and deficiency.
There should be a new tender.
Yes, when the in a condition, in the term and condition, there is no such provision that the more deficiency and less deficiency would be accepted. Who is the condition? Where it is written?
3 points. That's all of them have written. So there's
how-
part of the terms, they should be a retender.
Yes,
One should be selected. That's your point.
yes, this is my point. And now, I think my referee has submitted that in the entirety of the writ petition, there is no word of malafide. So he's not hesitate to say live before the court. Come to the para 16 and para 22 of my writ petition. Whether word malafide is inside the petition or not. I'll read out the para 16. I'll read out the para
One second.
of my writ petition. Here it is clearly mentioned malafide. But in spite of this written in the writ petition, he is submitting before this court that there is no word of malafide in the writ petition. So it is very easy for him to lie before the court. And now court comes to know how he is lying. Now, another point that exemption from certificate issue, whether a retiring officer who is not having any connection, either in the administrative capacity or as an income tax officer, income tax department, can he issue the exemption certificate, income tax exemption certificate? In this case, the exemption certificate has been issued by an unauthorized person, the person who is not having any authority. And come to the condition number 13. 13. Here also they have clearly violated. 13 is saying what
I think you
13 says.
mentioned all that. You have submitted all that.
No. 13 is then
No, no, mentioned that. Where 13? What 13?
no. Condition 13. Condition 13.
Wait, page one.
Page 112.
I think, one, two. Business turnover certificate.
A copy of business turnover certificate from RCS, Registered Cooperative Society. That this society has been running business turn of at least 1 crore in last 2 years. 14 years.
Oh.
Yes, here this has been issued from the cooperative, Registered Cooperative Society. Whereas in their case, it has been issued by a retired person, not a competent, he's not an authorized person. It's a violation of the 13 conditions of 13 of NIT. And here,
Where's that? Agent certificate.
certificate.
Page.
Where- Huh? In my case, 61 is to whom it may concern. This is to page 61. Certified that the annual turnover of the MS Nangyon Namsit Multi-Purpose Cooperative Society LTD of Pejirang Circle, Head Office Pejirang Nangyon.
This is your case or piece of.
No. My case is that my case has been issued from Register of Cooperative Society.
Okay, this one.
But in his case,
Page 61 is your case.
in the government affidavit, the government affidavit 136.
We responded, private responded. We included. There's no 136 here.
Page 89, man. Read better. Page 89. Audit note. 80 gold. T-A-H-H-T-A, retired. And
Okay, 80 goes is a retired person, huh? Retired by a retired person. Okay. This is the response, private response.
private response 7. He completely not accepted the violate the term and condition of particularly in 30. Then
Okay, so you're saying that he has more deficiency, there's more deficiency in this, when in this gender than yours.
yeah, what is my conclusion is that as per term,
He's not competent to be selected, that's
Yeah.
your point.
3 years, 3 years, but he has not completed 3 years. His farm was returned in 2022 and tender was all in 2024.
That I think you have mentioned.
So that is only 2 years. So as per the term and condition, he must complete the 3 years. And when they have sold the account, they have sold from 2021. Whereas at that time, this very farm was not born. And even these 2025, they have sold. But whereas 2025 was not come. The tender was for the 2024. So all the documents are invalidated documents. Now, main point of the case is that the deficiency scale, 2 notes of track depart submitted, which is renewed by the DTO. DTO is in the office of the AGC, Paketesa, and we have clearly stated that it is in renewed. The renewed is on offline. So they can take it, they can check it. Because the record was not in my custody, the record was in the file. Now, track number suction chart expired on in my PUC, pollution and control. Pollution control was not given in the conditions of the
Now what are you reading? Serial number?
I am reading the page 48.
Page 48.
Page 48. Page 48. Now, track number such and such. PUC expired on 29/10/2024. Whereas, in the term and condition of NIT, there is no such word of PUC, and it is not the ground. Now, another interesting thing that the perfect shop Gaylord of Sagyosa and Dishin Patao Sarkul submitted complaint by Chasentar Neil Chasentar against the farm of less delivery of rice like 38-35 in place of Chasentar. Now, in this case, 134. 134. What? Annexure 22, page 134. This is to certify that MSNN Multipurpose Cooperative Society LTD has during as district PDS there is contractor of respect of participation period from 2020 to 2024 successfully. Now, this ground number C it was written on 6/1/2025 and on the same day
2000, okay,
the department has given clarified that 6/1/2025 they have issued the certificate. That means when department has this certificate, this go experience certificate in that year, they cannot take the ground for C because
what's C? That's page
the page 48 of page 48
48, C. There's
Ah.
a C here,
there is serial number 2.
page number 2.
No, serial number 2. Serial number 2. Board proceeding.
Oh, okay.
Board proceeding. So this is also C is also not comes under term and conditions of the NIP.
You have made all these submissions. So this has to be the reversal, what they are saying. First point.
No, they have given the deficiency ground and shortfall ground. This is the finding of the board standard. So, from my submission, I have found that entirety of the term and condition of the term and condition of the response number 7, that they have highlighted and they have not fulfilled, but it was not mentioned and detected by the respondent.
Next two. They have not mentioned all this. They have only mentioned one point. Insurance expired.
Huh.
Only that.
No, insurance expired.
No, that's just respondent number.
No, PUC. You may position under position control. Michael. This was with us, but we were not sure.
Okay, so
But-
you're saying this point number B.
Hmm.
Truck so and so PUC expired on this is not correct. You said it's not
Yeah.
correct.
It is not
What is correct?
correct is that they have not sought us, and it was not fall under term and condition of any.
Okay. Not as per the conditions, terms and conditions. So they say that this is no ground for rejection.
Yes. This is not the ground for rejection. Now, in my para 14 of my research,
I thought that
of my read petition. So, in this case, the term and condition varies
this is
from
not mentioned.
NIT to NIT. So, the term and conditions of other NIT, the ruling which was passed cannot be imposed in our case. Because here in our case, there is no qualification, election. There is only the say that deficiency and so forth. So
Okay,
according
I'll
to
have a look whether there's smack of Malafide and something
Yes.
in rejecting you?
Yes.
Choosing respondent.
Yes. In para 16.
Para 14 and 16
No,
of
no,
your
no,
objective.
16. I have clearly mentioned. Para 16. That the petitioner stated the private respondent number 7 is a person of hand in glove. Though there are numerous and serious lapses in the big document of the private respondent number 7, the authorities have remained deep and blind and ignore all the mandatory requirement of the tender. From the conduct of the responding authority, it is seen that the private respondent number 7 and the respondent authority have some closed door understanding. The respondent authority have with the malified tender. This is the malified word. And in order to grant tender work to the private respondent number 7, has deliberately ignored various shortcoming of the private respondent number 7 that for the interest of justice, it is pressed that this honorable court may please to what and said SIT impugn the evaluation report dated on 1/10/2025, accepting recommendation and approval dated on 12/2/2025, signed on 14/2/2025, the breach of the private respondent number 7 and pass other consequential relief to reevaluate the bid and recommended the name of the petitioner. Now,
Now, at this stage, reading a writ petition is not required because that is what it is understood. In rebuttal, you have said that there is malafide.
yes. Now, in support of the
Huh.
2025 HC, putting one line each. Thank you. 1940. Paragraph.
Yes.
In the circumstances where claim all the first respondent that contrary to the terms of the enactment and fairly rejected the appellant bid for non-production of the joint venture agreement, although clause by the did not prescribe production of such an agreement as mandatory to rely on past experience of such a condition in which their leader had defined proposal chair, proposal chair. Another way, I have already placed it. 2024 CT 9G 2700. Para 21, 25, 29,
Where is it listed when? It's not here.
I and
Okay, so you are relying on which judgment? Number one is the one which you just gave me, isn't it? 2025 part, this one, hard copy of given you. The second one?
para 34, para 39.
No, but it's not. It's like it was not. It's temple and capital. relying on authorities. So one is the 2025 SEC, 1942, and the other one is 1976, one SEC. That, second one, Para 34 and 39. What does this say? What is this about?
Have laid down the number of procedure that have their local both the other and only the one who has personal or individual rights something without the ability to
So
do.
you're saying you have local standing in this matter. This is what you're trying to. Then, so your third judgment. Para 21, 25, and 29. Where have you placed this judgment? This is 2024, SEC online, 2700. Why have you given me the judgment? What is, yeah. Technical bit. For non-compliance of, like,
Bias. No transfer. No clarity.
okay, got the point. They're challenging the selection. We'll leave it at that.
Well, can you give me 30 seconds?
For what?
Sir has used the word light. I have lied before the court. Now, this interpretation, Milord, German is a German song, especially of the Romantic period, typically for solo voice with accompaniment, Milord. One. But, Milord, all the rebuttal which he has made has could not revert my argument on the lawful standing, and he has also not successfully reverted as to why he has withdrawn the read petition number 95 after withdrawing the EMD as to how he has filed the read petition has not been answered. So therefore, my lord, he has not given that. That's it.
Assisted by Mr. So that it council. Council.
So, I think, item number 5.
Hmm.
I propose cancel the theory secretary for that. That may be correct. Applies.
Okay, Lordship, it is issues the petitioners are Ayush doctors who are serving districts of Arunachal Pradesh. So, this petition was filed challenging the Indian order passed in the year 2007, Your Lordship, wherein Ayush doctors were deployed to render emergency duties. Your Lordship may see for a moment the Indian order, Your Lordship. That is at page number 99. Page number 92. This is the Indian order. Yeah. The district medical officer, all the districts, Arunachal Pradesh, emergency duty, subject emergency duty. Sir, the mainstreaming of IUS under NRHM envisage involvement of the IUS medical officers into the mainstream allopathy, involve the health facilities of the state. The process includes participations of IUS MO in delivering emergency duties similar to allopathy medical officers MO. Therefore, you are requested to see that the IUS MO under your disposal are maximally involved in delivering quality health service to the population. It must be ensured that they perform the emergency duty just as allopathy MOs are performing in the health facilities. So as per this model, IUs are supposed to deliver emergency service similar to allopathy. So now after this input order, the petitioners have made representation seeking clarifications. Suppose we are not against emergency duties, but while discharging emergency duties, whether we can, the petitioners, the IUS doctors can prescribe allopathic medicines, and whether we, that the IUS doctors is supposed to do the emergency duties within the own system of medicines. That clarification was over. So since 2008, we have filed several presentations, and the latest one is at page number 155. Dated 19 January 2020. Last year. Yes, Your Lordship.
No response to it.
No response taken. So therefore, finally, having no alternative, the petitioners have come before this court. And
So, in your representation, you have mentioned some other states.
yes, Your Lordship, because in some other states, the
Notification will pass.
yes, some circulars were issued.
That you cannot
Yes.
prescribe another.
Yes, regarding prescription from and of the parents. Yes, Your Lordship, because we IUS, we practice within Indian system of medicines, and emergency duty, Your Lordship, requires immediate medications, Your Lordship. So now, since we have been deployed for entering emergency duties, at times we are compelled to prescribe allopathic medicines without any authority. So it now
Yes.
so many representations. Now, Lordship, they have 5-year applications. Transport authorities. In entire affidavit, they have stated that in the input order, they have not asked the IUS doctors to prescribe any allopathic medications. So that step they have taken.
So you don't prescribe medicine. So
Now we
just
can,
there.
yes. So now my prayer is that, Lordship, regarding prescriptions of allopathic medications, they have taken the stand that they have not standard any prescriptions of allopathic medications. But now the problem is the duty rosters of GMOs, emergency medical officers. It's a common rosters along the MPS office. So now what we are praying is that at least give us a separate duty rosters, parallel, so that IUS doctors will also be here, MBBS doctors will also be here. At least the patients, they can have their own choice of treatment. So that clarifications they have well to.
Have you mentioned that in your petition? That part, that travel.
That specific prayer we have not done.
So have they addressed, can they address that issue?
We have addressed that issue. That we are compelled to.
Okay, so you don't prescribe any medicine.
Yes, Your Lordship. Now they have taken that step. But at least some order, let the state, let direction.
Let's see what they have to say.
Yes.
Yes. So they're not required. But perform emergency duty just as allopathy MO. So when you are doing your duty in the emergency, you will doesn't prescribe only a
That is there. But since the lordship, as I have submitted the roster, since the roster is a local roster, the IUC doctors are based along with the evidence, along with the MBBS doctor. So at least the authorities want to have make parallel process so that IUC doctors will also be.
Anyway, so we can dispose of this petition, get an observation that they in your counter, we have said they are not required. So
Yes.
we can say that they are not required.
Yes, yes,
That's
that,
right.
yes.
Okay. And then the state should ensure that the health and the life of the state are not endangered by making sure that there's a proper
Yes.
to look after the patients and
Because in IUC, we don't have any life-saving drugs, you know, we don't have.
so that they should take, the state should take, that's, I'll dispose of accordingly.
Yes, you know.
The writ petition, so they're not required to, I've not read your counter, but in your counter you've mentioned.
Yes. So we can the out doctors to render emergency. What system of medicine?
Yes.
Not beyond that. Okay.
What's the order later?
Item number 11,
So lastly, I might like to bring to notice of your lordship that respondent number 1, 2, 3 have not yet filed my affidavit. There is a serious allegation against the conducting authority, tendering authority. That no opportunity has been given to me for participating in such standard procedure. I have been debarred from, technically debarred from participating in the tender process. So therefore, the affidavit on the part of the chief engineer, as well as the superintending engineer, who once issued corrigendum for the postponement of the proposed opening of the tender.
Who's representing? Anyone representing, you're representing them also. Who's representing?
Not by the respondent number 1 and
No. See, he is saying he will be representing the other.
representing is one thing, my lord. The notice I may be allowed to serve a notice to the
But
person.
let's see.
My lord. Otherwise, my lord, the affidavit on the part of the respondent number, it is not known whether they wanted to file the affidavit or not, my lord. State government has to at least file, my lord, in such serious case. Allegation is very serious, my lord.
Was notice issued.
Notice issued long days back, but my lord, they are not responding on behalf of my lord, respondent number 1, 2, and 3, my lord. Rest of the respondent they have filed, my lord. We have no any objection, my lord. But in such a serious nature of open, my lord, the
But they are
procedural lapses.
government officials,
No, my lord.
private, right? They are private.
No, madam. Government official, on official capacity, madam.
Oh.
Respondent authorities are doing all these activities, my lord, within,
So if the, this thing,
my
so
lord.
if the respondents, they're saying that they're representing the other government officials also, if they're covered,
My lord, at least notice is to go to these respondents. Because,
they're government officials, it's not a contempt petition.
madam,
It's not a contempt petition that their personal capacity. That is not required. So the,
Madam, what happened
that
basically,
is,
these officers are being managed. What I'm making submission before your lordship is, these officers are managing by their own capacity, madam, not without any approval of the madam. Just I'll show your lordship one document which has been, madam, issued by the higher authorities, madam. These are the subordinate officers of the higher authorities. Even higher authority has no knowledge about the, madam, the pendency, madam, even. Or there is no any correspondence that no affidavit is not required to be filed by the respondent number 1, 2, and 3, my lord. Had there been, my lord, that would be, my lord, the cover up. Obviously, my lord, they are the head of the authorities, my lord. My lord,
no, but ultimately, it is the state, isn't it?
yes, my lord.
It's a state, this thing, it's a state respondent who have to answer,
Yes, my lord.
not the personal, this thing.
Yes, my lord. Therefore, my lord,
But
may
they
I
have
take your
to
lordship
answer
to
on their
my
behalf.
course title, my lord. Course title, page number 5, my lord, of my report. The state respondent has to also answer, my lord.
So you mentioned that maybe the editor will say that he is also representing the respondent.
To my understanding, my lord, representing is one thing, my lord. And the making correspondence from the concerned department is another thing, my lord. That has to be, my lord, brought on the record that yes, they don't want to file affidavit, my lord.
But is there a standing counsel for the department?
No, my lord. Respondent number 5, my lord. Oh, sorry, my lord. Page number 5, my lord. First respondent, my lord. My lord, the executive engineer, by virtue of, my lord, his official capacity, he cannot represent
It's a standing counsel for the
PWD, my lord, they don't have. My lord, respondent number 1 is the, my lord, the or state of Arunachal Pradesh, represented by the commissioner, my lord. Number 1. And number 2, my lord, the respondent number 2 is, second respondent is chief engineer, my lord. And third respondent is superintending engineer, my lord. Now, before your lordship, affidavit has been filed by respondent number 4, 5, and 6, madam. Only 3 respondents.
So he's fighting on behalf of.
Not, my lord, as I have pointed out, my lord may kindly peruse the affidavit filed by the respondent number 4. Just for a moment, my lord. This affidavit has been filed by the respondent number 4 himself, my lord, not on behalf of the other respondent. Just may I take your lordships to the affidavit filed by the respondent number 4. This is my another limb of submission, my lord. No, my lord. Not it.
Respondent number 4.
kindly, my lord, may peruse the the affidavit filed by the respondent number 4 at page number
So maybe respondent number 1, 2, 3, and 4 on their behalf, no, 3. Maybe the additional AG will say that they will not be filing their counter affidavit. As simple as that they want to file, because it's representing the state government. We'll make that on record. They will not be filing,
madam.
isn't it?
Therefore,
Make
madam,
that on record that they say that it not be, that they won't be filing.
Yes.
counter. Cannot insist that they
madam,
will
at the
file.
very first, madam, outside, madam, just I bring your notice of your lordship about this another aspect. Madam. Of course, madam, I'll go to the merit of the case, but this is the first aspect where it is required to be filed by the madam. Is that respondent when they have made as a one of the respondent, madam? What allegation, madam? What I'm madam, making is
Or maybe the
state
additional AG can get, we can at least give a chance and get instructions, because ultimately to be the addition is filing the affidavit of the department.
but then
Yes.
there must be
But
instruction
whether,
from the department.
get instructions whether this thing, formal instructions, whether 1, 2, and 3
Correct.
will be filing their counter. Then you find out at least what is satisfaction, but I
Correct.
don't know whether what 5 and 6. See, here,
It
uh,
will
on
affect the cases
the
of
order
case.
dated 2507, 2025.
It will be malad. It will
So-
bearing malad.
See, in the order dated 2507, the first order, okay? Here, the additional AG accepts notice on behalf of the state respondents number 1 to 4. So no, it's already accepted notice.
Malad. However, malad, except notice has been accepted. My lordship may kindly again peruse the affidavit filed by the respondent number 4 at page number 83, malad.
So if you don't have enough counter affidavits, it's in your interest.
Yeah.
If they also
So,
find their counter,
that
then,
part I-
then your case will
That's
not
what
be
I'll.
strong. So
No,
don't-
malad.
so-
This is another aspect, malad. I just want to bring the notice of dishonorable court that affidavit on the part of the respondent.
They don't want, so less counter
My lord.
affidavits in your interest.
Yes. Now, malad, merit of the case is lordship peruse my malad. NIT malad was issued by the respondent number 4. Lordship will file the impugn NIT malad at phase number malad 29. It starts from page number 29. Annexure 3 malad of my decision. This is the malad the impugn NIT issued by the respondent number 4. Respondent number 4, madam. The technically, madam, the impugn NIT is, madam, it was issued on 30th June 2025, madam. And that of madam, if lordship peruse at page number 32, madam. Madam, just serial number 6. Before that, madam, I'll read them. The executive engineer, Yamsa Division, PWD, AP, on behalf of the governor of Arunachal Pradesh, invites online item rate e-tendering in double bid system. Madam, may kindly peruse, madam, note the double bid system. Double bid system from registered soil. Name of the work is, madam, upgradation of Yamcha ADC headquarter, Tulirmoba EAC headquarter under so and so. And madam, may kindly see page number, oh sorry, same page, serial number 6, milestone date of e-tender. Serial number 1, date of online publication, madam, or 30th June 2000, same day, madam. And documents, sale start date of that date and time, 30th June, same date, madam, 30th June, so and so.
And my lord, serial number 3, documents download in date and time, my lord. 14, my lord, this is important, 14/07, 2005, 25, my lord. 2025. Time is also given, my lord, in time column. Pre-bid meeting, my lord, that is not, my lord, 3. Serial number 6, my lord. It was supposed to be open on date and time of the opening of the technical bid, my lord. 15 June 2025, my lord. And my lord, serial number 7, important, my lord. Date and time of opening financial bid to be notified later. It is not specified, will be notified later once technical bid is complete. And serial number 8, my lord, physical submission of earnest money, deposit, so and so, tender B, so and so. My lord, date, it starts from 30th June 2025 to 5th July 2025. Here, my lord, I'll pause for a moment. My lord, last date of technical bid will be open on 15 July 2025. Last date, my lord. No, my lord, it is not last date. It is date of opening of technical bid, my lord. Technical bid. But my lord, the from 30th June to my lord, 5th June, 5th July, sorry, 5th July is the my lord, date when my lord, the earnest money and other original document has to be submitted. The bidder has to submit all required documents in original on or before 5th July 2025. Whereas, the date for the last date of the submission of the date is on 14 July 2025. So, meaning thereby, they have incorporated this technical, technical, so as to eliminate, so as to render disqualified to the other intended bidder, except their own chosen the tenderer or the bidder.
So this last date, 14/07/2025
ma'am.
is the serial number 3.
Correct.
Download, document download.
Correct. Then, why it is required to be submitted on or before 5th of July, whereas last date has already been fixed by 14 July 2025. Then why this 5th July cutoff date has been given?
This document download is it is through this thing, tender.
Correct.
Physical is fine.
Yes. So therefore, this technical condition has been incorporated so as to the element the other intended bidder.
But supposing you cannot submit it to physical submission, then you can opt for document download.
No, madam. No, madam. That will be deferred. Page number, madam. Again, I'll take your lordships to next page number 34 again, madam. 33 is the other rest condition, madam. Not relevant. Page number 34, madam. Same date has been given, madam. Double lordship, I'll not order your lordships to.
Online is still here.
Yes, ma'am.
Then supposing you don't have the time to do it online. No, you don't have the time to do it through physical submission of it. Then can't you switch to online?
Madam, technically, the documents and everything is prepared in the period of 5 days, excluding my last submission. That is from 20th to 30th June to 5th July, madam. Meaning there were 5 days, 5 days. Physical documents, original, madam. Original documents has to be demonstrated.
Okay, so all those who are applying from download or this thing online also, the original has to be anyways given on day after
It will be not accepted, my lord.
No. So when you say physical submission, the original documents,
Yeah.
for those who are also applying to this thing online, have to do it up to the last date.
It is in 14, on 14, my lord, 14
No.
July.
You're saying serial number 8, physical submission.
Right.
When you say physical submission, all the original documents
Yes,
have to be submitted by 05.
correct, my lord.
Then after that, if there's any online documents, it will be 1407.
My lord, that will be clarified from page number 34, my lord. Page number 34, my lord. The period of availability of the online bid so and so, date time and so, serial number 1, my lord. Availability of tenders online for bidders, my lord. It is given from 30th to 14 so and so. That is the, my lord, the time period, my lord. But original documents has to be submitted on or before 5th of July, my lord. Meaning thereby they are reducing the, my lord, the number of days for submission of the original documents, my lord. Whereas bidding last date is still 14 July 2025. my lord. So meaning thereby the bidders who has not submitted the original documents on or before 5th of July, they will be directly disqualified, man. So therefore, that short date has been fixed technically so as to eliminate, so as to scrutinize the other intended bidders. That is the technical form. Now the page number, same page 34, serial number 2, I am skipping, serial number 2, 3, 4, I am skipping. Serial number now come to serial number 5, madam. From this clause, from this serial number, it is clear and transparent, married, madam. Bid can be deposited before the time is specified by paying the cost of bidding documents, non-refundable, madam, in case of arrest 10,000, along with EMD and other original documents to the executive engineer, Yamsa Division so and so from 30th June 2025 to 5th July 2025. Why this clause is been incorporated, man? Whereas, just serial number 1. Serial number 1, date of bidding is given from 30th June to 2025 to 14 July 2000. Altogether, 14 days. But the submission has to be done. As I am repeatedly pointing out this point, this is the crux of the case, madam. Original document has to be submitted on or before 5th July 2025. During office hours, I am continuing serial number 5. On or from 30th June 2025 to 5th July 2025, during office hour at the specified opening place for the work listed in the tender. Before submission of the online bidders, the bidder must ensure that the scanned copy of all the necessary documents have been attached with the bids. Well, this is the requirement. The details of the cost of documents and bidding security specified in the tender documents should be same as submitted online, madam. But online, one part is online, and another part is the physical submission of the original document, madam. And in original documents, madam, they are saying there, madam,
Last date is 05.
correct, madam. Now, madam, on 5th, madam, preparation of documents in just tender process, madam, it took several days, several times, madam. It will be not prepared in a day or in a night, madam. It requires some documents which has to be compiled. So compilation of the documents cannot be done within a period of 2 or 3 days, madam. 5 days, madam. Whereas last date of submission is, madam, 14 July. This is much ahead of the last date of submission of the tender documents. Now, my lord, even after that, my lord, petitioner being the intended tenderer, Malat submitted the Malat went to the office of the Malat the executive engineer to submit his bid documents. Enter bid documents, Malat. More particularly, Malat, may I take your lordships to the important part of the Malat the interest letter documents. Important part of the documents is Malat page number Malat 656 Malat annexure 5. This is the Malat the earnest money which has to be deposited with along with other required documents. This is the Malat the bank guarantee Malat to the tune of Malat 39 lakhs 70,000. It is against the Malat API is fixed by them. Malat. Therefore, Malat, I went to the office of the Malat the executive engineer, respondent number 4, submit the Malat bid documents.
When did you do?
Malat on 4th, 3rd, 4th. On 3rd, 4th, and 5th, Malat, executive engineer, tendering authority, Malat, he remained absent entire Malat duration. Therefore, Malat, the petitioner has been Malat, prevented from submitting tenders, bidding documents. Thereafter, Malat, having no other option, we filed Malat therefore, Malat, affidavit on the part of the respondent number 1 is required, Malat. Page number Malat 57, annexure 6. Malat, I made a representation before the Commissioner, Public Works Department, Governmental Wellness Service on 4th July 2025. Malat. Subject representing regarding arbitrary and unfair conduct in tender process and requesting immediate interventions for the modification and cancellation of that I'm reading page number 57. Sir. Tender condition NIT number so and so dated up work for this also. Malat, with details, I have submitted this representation for the concerned authorities responded number 1 more particularly. And that has not been immediately still there.
The counter accepted whatever you have.
Yes, ma'am.
No favor.
Yes. Correct. Page number Madam 60 again, Madam. Another representation which has been made to the chief engineer, Madam, who has not been filed, Madam, affidavit. Page number 60. This representation is also submitted to the chief engineer, Madam, respondent number 4. Sorry, 3. Sorry, respondent number 2. Madam. On same, Madam, 4th July 2025. Madam. And as of now, Madam, there is no response. And in their counter affidavit also, there is not Madam specified. And again, Madam, another respondent number 3, Madam, page number 63. Same representation has also been made to the Madam superintending engineer, respondent number 3, Madam. Madam, on receipt of this Madam, the representation, executive engineer, Madam, on same, Madam, page number 66. This representation is also made to the Madam, executive engineer, Madam. On same date, Madam, 4th July 2022. Same grievance, Madam, almost same, contents are same. However, Madam, and Madam, after Madam submission of my tender documents before the Madam, I went to the office of the Madam, executive engineer, along with all the original documents, Madam. Madam, the executive engineer will remain absent for all this period, Madam. That will be, Madam, clarified from the page number 68, annexure 8, Madam. Type copy is, Madam, page number 69, Madam. Married. 69 is the type copy, Madam. Since it is handwritten, Madam. Madam, contents of this copy is very important. We, the undersigned, has been assigned the work of the recipients to processing fee, Madam. Unless processing fee is received, they can't process, Madam. But from the affidavit filed by the respondent, it is statement just for a moment, Madam, just to clarify this aspect. They are stating that we have submitted the bid documents, but some documents are not as per the terms and conditions of the NIT. Whereas we have not submitted any tender document. Processing fee has not at all been accepted by them. How come my tender documents has been examined? We the undersigned the had been assigned to work of the receiving the processing fee and earnest money deposit, madam. So far, we have not deposited earnest money, madam, till date. From the tender bidding for the work upgradation of so and so, duly after the application and tender documents have been verified by the executive engineer and Yamcha PWD division, but madam, due to absence of the concerned authority, madam, none other than madam, respondent number 4, executive engineer tendering authority, madam. But due to absence of the concerned authority, the person assigned for the receiving the forwarding the application could not provide us with the said application, and that is why we are unable to receive the processing fee and EMD from so and so petitioner company, man. Petitioner company and one Rinya Yangfo Malat Construction. But who has given given this statement testimony before this before the petitioner was junior engineer of same department, whom the assignment has been given. Just below, madam, name of the junior engineer, Yamcha Pidu, Sri Jungken Karpa, junior engineer, Yamcha Division, and Mutu Yamcha junior engineer. Two juniors engineers officers has given the statement that no, we have not received any the processing fee and the earnest money. Another testimony given by the same officers of the same department, same division, page number 70. Type copy is at page number 71. Married mind. I the undersigned, being an employee of the PWD Yamcha division, was assigned the duty of the receiving the applications from the tender bidder for the work so and so with effect from 30th June 2025 to 5th July 2025. Last date of submission, last date of opening of tender, even downloading parties on 14th July 2025. But
Not
this
date, but you manage. You're saying you manage that short date.
no man.
Short date.
Even
you
we went to the office of the executive engineer along with the
within that short date, went.
yes,
No.
we have managed, madam. We have managed. We were ready to submit the contentions of the this particular officers is our tender has not been processed. We have been prevented from this receiving the tender document, original tender document.
But here it says received application.
Receipt that has not been processed. Next line, on the 3rd July 2025, I have received the applications from MS application. That application with tender documents by annexing the entire document required under the terms and conditions of the tender. Received from so and so company, station so and so Tulian. And on 4th July 2025, I have received applications from MS so and so, two bidders, tenderer, independent tenderer. So it's and last portion is very important. What they are saying is, yes, we have received the code, but that has not been processed. I have forwarded the said documents to the EEPWD Yamcha division for verifying the bidder documents for the further pursuit. But he was unavailable at the division office during office hour from specifically mentioned from 3rd July 2025 to 5th July 2000 due to reason not known to me, madam, who has given this declaration by the Tamkin company managers below, type of SD, and witnessed by Mutu Yamcha, J. so and so, witness number 2, so and so. 2 witnesses also given that the officers were not remained present, so and so. So therefore, which the tender of the petitioner has not been processed. Technically, I have been prevented from submitting these tender documents for participating in just tender process. That is my case. And having no option, we approach to the higher authorities. That's why on the very beginning, I made submission that the response, the affidavit on the part of the other respondent is required, is because, madam, being the superior officer issued notification, madam, may she, kindly see, madam, the corrigendum to the notice inviting tender, madam. This has been issued by the just higher authorities of respondent number 4, respondent number 5, respondent number 6, madam. Mary, this type copy is page number, madam, 73. The government of Arunachal Pradesh, office of the madam superintending engineer, so and so, madam, this is superintending engineer, respondent number 3, madam. Name of the corrigendum of notice inviting tender, madam, so and so, so and so, madam, so and so, madam, I'll skip this part. Now, madam, following corrigendum is being issued to the above NIT document and to be read is below, madam. Madam, corrigendum has been issued by extending the date, madam. Free date, pre-beat start date and time, madam. 10 July, madam. Corrigendum has been issued by the higher authorities. It is 10 July 2025, madam. 10 a.m. madam. And pre-bid end and date time, 10 a.m. So, madam. The physical submissions of the EMO, madam, that remains, madam, same, madam. Serial number 3, madam. Physical submission of EMO, madam, tender fees and necessary documents, madam. This has been extended, madam. Remark column, madam, next column. The tender fee original document, original copy of EMD and a copy of the contractor registration should be submitted to the executive engineer YAMSA division at YAMSA from 30th June 2025 to 10 July 2025 during office hours. Meaning there were another 5 days has been extended, but that has not been taken into consideration. They have not, extended. They keep on going forward and processing the matter, but having no other option due to the rueful play on the part of the respondent number 4. But we were compelled to file the FIR before the matter concerned police station. Lordship will find at page number 74 and accepted. This is the FIR, madam. Complaint seeking registration of the FIR regarding the deliberate obstruction, madam, criminal negligence and the malevolent conduct by the by Siri so and so executive engineer, madam, respondent number 4 and the respondent number 5 himself. Madam, this is the FIR. Madam, I'll take your lordship to the next page, page number 75, madam.
So now you're saying on that day when you submitted,
Madam,
since they were not available,
available in the office deliberately, madam.
then since the date has been extended,
That has not been even considered, madam.
then they consider after that up to 10.
No, madam. That is not, therefore, we have been prevented, madam. We have not submitted, madam, as I have pointed out, madam, we have not submitted any tender document till date, madam. But by way of affidavit, they are saying that no, your affidavit, madam, tender has been scrutinized by the board, madam, and they are rejected the bid of the petitioner.
So then, the same, page 71,
Madam,
come back to page 71. Here he says, I have forwarded the documents.
madam,
The documents submitted by you.
correct, madam.
The
Madam.
PW. So now it has been forwarded, then did you take it back? Because he was not unavailable.
Madam, it has been forwarded without original document. That is the photocopy, madam. It has not been, madam, accepted by the madam. Only, madam, the original documents has to be very
So
specific.
why didn't you submit your original?
Original documents says, madam, this is the case, madam. Original documents they have refused to receive. They were not remain present in the
But
office.
what is page 71? I have forwarded the same documents.
Madam.
What documents have been submitted?
Madam,
Page 71.
page 71 is, I have forwarded the said documents to the E.
Documents which you submitted.
Yes, madam.
isn't it?
Yes, madam.
And what documents?
Documents, it is photocopy of the original document.
Why did you submit your original when last
Madam.
date for original was
Madam,
filed?
that is the crux of the case. Original document has not been received, madam.
But see, you.
My lord, may kindly appreciate it and my lord may kindly appreciate this is the photocopy and original documents is to be produced before the
So, when you approached,
my lord.
you submit your agenda.
Well.
When actually all date was five July. July. That is the last date for submission.
Well,
Then when you put the last date for submission of the fifth July. Then why didn't you submit your original document?
Madam, as I pointed out, it is the categorically stated in my big petition also that my madam not being cheap. This
Then
is
what
the
is this document?
original documents, madam, then the documents as I pointed out,
So
madam.
when you file the application, you know which one? Two applications were received,
Well,
one on 037, and the other one on 047. You are which one? What? You are which one? What's the name of the petition? You are the
Madam, I am
Vandi Rai Company. Vandi Rai Company on 0307.
it was received then.
So
And another thing was received from the another madam independent readers.
So when you went
Oh.
the application, why
Malad-
did you carry your?
My lord, may kindly appreciate, lordship, may I take your lordships to again, the terms and conditions is stipulated in serial number 5, page number 34 again, madam. Madam, if we read this clearly, madam, everything will be come out. If either the document so and so, original document, non-refundable in case amount of so and so, along with EMD and other original documents, madam. Madam, they have received, as I pointed out, photocopy of the documents has been received. It is not required to be, madam, even, madam, forwarded. This has already been, this has to be, madam, uploaded in the event website provided by them, madam. Original documents first has to be, madam, madam, may I read again, madam, serial number 5, madam.
Five.
Each can be decoded, madam.
So this much rupees, 10,000 you approach that.
Correct. Along with EMD, madam, which is the crucial documents of intention standard process, EMD, earnest money deposit, madam.
So along. with the
Original documents, madam. My original document has not at all, my lord, received.
So
Madam,
when
where
you
is the receipt copy, my lord? Record may be, my lord, call for then in that case, madam. My original document has not yet been received, my lord.
So when the money went on a third, you went without your original document.
As I pointed out, my lord, my EMD documents is, if lordship again peruse my EMD document, it was drawn on, my lord,
On second,
correct, my lord, on second.
so with your EMD documents and your original, I thought you were.
I have to, my lord, submit it first before the officer concerned for, my lord, verification of the original document first, madam.
And
Then-
it's not there.
That has not been done, madam. Then after it will be processed along with the processing fees. Then after it will be, my lord, included in the, my lord, the tender, my lord, the participating list. Original documents has to be demonstrated first, madam. Then it will be forwarded to the, my lord, forwarded. Then it will be taken into consideration.
Then later, it was extended, then, July 2025.
More
it's
interestingly,
actually
madam.
there. So when it was extended.
Extended has not been very interestingly, extended has not been taken into consideration. Even in their affidavit, it has been clearly mentioned that, my lord, that extension has not at all been considered by the respondent number 4, and they, my lord, often the tender without, my lord, extending last date of submission. So therefore, that will be, my lord, more clarified from the affidavit filed by the, just for a moment, my lord, just to get,
Because I'm not really. What I don't understand is when the time for submission of documents, was on 0507.
correct, ma'am.
Why did you hesitate to submit your original document?
My lord. My lord, that is the point which I am raising. If no one were here, man, whom to submit, madam?
You submitted it before someone and whatever.
No, madam,
document
someone
you
is not allowed, madam. They have not, madam.
So these documents which was forwarded.
Madam, that is the crux of the case, madam. Madam, if I am prevented, madam, just for a moment, madam, may I take the example like this? If original document, the learned additional AG,
Because, okay, so because the he was not there, you did not want to submit the audio.
they have not at all, madam, accepted.
Then
Now, my lord, even if it is just for a moment, my lord, I don't want to, I don't know,
I'm trying to understand.
hurry in, my lord, hurry in, my lord,
Yes.
the brought to the notice of this honorable court regarding the affidavit filed by the respondent number 4, more particularly. My lord, this has been, my lord, lordship has already seen. Last date of submission is 5th of July 2025. Lordship has taken note of it.
So you went on the 3rd to submit.
On 4th also, my lord, on 5th also, but nobody was there, my lord.
No one was there. Some
Executive engineer, madam.
Okay.
Executive engineer, madam, specifically this mentioned.
So you are saying these documents because they were not there, the he was not there.
Yes, ma'am.
So you did not submit your original document,
Correct.
you just submitted an application. Without document.
Application is one thing, madam. When I made bulky, this standard procedure, madam, entire documents has to be enclosed. One application enclosing the entire document has to be given to the madam authorities for accepting, madam. And then
Just an
authority,
application.
madam, then authority, what they will do is, first of all, they will verify the original document. They will accept after verification, after taking entire thing, they accept the photocopy for consideration in the technical board. Madam, more particularly, even processing speed, my processing speed has never been accepted. Where is the melody statement that madam, they have accepted the processing fees? They have accepted the madam, my EMD. Madam. Still, I am retaining my EMD. Madam. EMD has to be written by them only. Madam.
So your application is simply, what was the copy? Can you give me a photocopy of your application? What was received and forwarded to the.
Madam, Madam, that I can participate.
That, so
Then-
that you
then
can
ma-
show, no?
Yes, madam.
Because then I'm not understanding page 71. Where it says that your application was forwarded to the.
Madam, page number 70, what can be correctly understand from the previous page? Page number, madam. Page number, madam, 71 can be, madam, more clarified from page number 69. This is the contention is same, madam, and the obviously same. We, the other side, have been assigned the work of receiving the processing fee at earnest money, madam, deposit from the tender bidding for the work so and so, after duty application, madam. And tender documents have been verified by the executive engineer. Madam. This has to be verified, madam. As per clause 5. This has to be verified by the executive engineer. But due to absence of the madam, concerned authority, the person assigned for receiving the forwarding of the application could not be provide us with the said application. And that is why we are unable to receive the processing fee and EMD money. Okay, I'm asking myself, can you, the department process without accepting the original processing fee or without the EMD? EMD and the processing fee is the crucial documents in the such standard process. Time and again, I am pointing out this.
Okay, so that was not accepted.
Not accepted at all, madam. Only
Was
simply
that-
accepting the photocopy which has been which I have done. They simply accepted my photocopy, madam. Madam, that will be lordship has already taken note of it. Then the bidding process will be start from 30th June 2005. Madam, 5th July 2025.
Extended to 10.
Extended to 10. But my lord, my 10 bid has been rejected. Lordship, may I take, madam,
Where's the rejection letter?
as per their contention,
Okay.
this my bid has been rejected, already rejected, madam. Without considering madam, without receiving my processing fee, without receiving my original assessment of EMD, without other original documents, madam, premature rejection has been done by. Just for a moment, may I
No,
take your lordship
uh,
to the affidavit filed by the respondent number 4 at
Four.
page number 118. This is the full play done by the exclusively done by the respondent number 4, respondent number 5, respondent number 6, my lord.
one,
Affidavit filed by the respondent. Just for a moment, my lord.
Ah,
From this document, lordship will be very clear how this full play has been done, my lord. Respondent, page number 118, my lord, internal page number, continuation page number 118, my lord. When documents are to us, my lord, without verifying the copy, my lord. See that, my lord, my lord, compared to Excel, once it is issued. But my lord, it is not clearly paginated, and some pagination is missing also, my lord. However, my lord, may I take your lordship to the page number 118, my lord, may I read, my lord. Government of Arunachal Pradesh, Office of the Executive Engineer, my lord, respondent number 4, PWD, so and so, my lord, that has been given, my lord. Kindly note, my lord, that 03, my lord, it is handwritten. Fill the form. 03/07/2025, my lord. Lordship has already seen. To series so and so, that is me, my lord, authorized person. Non, my lord, subject, non-fulfillment of section 3, condition of contract under additional special conditions at the time of processing P regarding, my lord. Again, my lord, they are talking about processing P. Reference, my lord, it is same. Sir, with reference to your participations in the bidding process for work so and so, so and so, it is hereby, it is only hereby informed that at the time of submission of the collection of the processing fee, it was observed that the required is stipulated under section 3, condition of contract under additional special conditions to be not fulfilled, my lord. Section 3, my lord, I'll come to again that part. My lord, just for a moment, my lord. What they are saying is you have not, my lord, complied the my lord, section 3 that has been, my lord, whatever is the condition is stipulated in section 3 that has not been fulfilled. Therefore, we are rejecting your document. My lord, kindly take note of this that this is 3rd July 2025, my lord. Whereas, even if it is not accepted, my lord, last date of submission is 5th July. Even if it extension called by way of corrigendum, if it is taken into consideration, that will be again then again. 3rd July, madam. Madam, premature rejection, madam. Even if I submitted, madam, technical bid will be held on 15 July 2025. Now, my lord, what that section 3 is saying, it is at page number, my lord. I'll take your lordships again, the terms and condition which they are referring is at page number, my lord.
yeah, writ petition.
No, madam, same affidavit filed by the respondent number 4. Here's one clause where, my lord, the page number, my lord, 108, my lord, annex 2 of same affidavit, my lord. This will be only rejected when technical bid is done, at the on the opening date of the technical bid, not prior to the method. Yes, correct, ma'am. Correct, true, ma'am. That is the method. My correction. Page number, method 108, annex 2, serial number 26, method. Processing P shall be collected from the division office PWD from the assigned persons and duly countersigned by the assistant engineer. YAMSA PWD subdivisions by the bidders or public authorized representatives on production of the bidder's original identity proof, with PAN card, Aadhaar card, contract registration certificate on 30th June 25 to 5th July 2025, failing which no processing fee shall be received or processing fee received not in order shall be summarily rejected. And premature rejection cannot be. That is the whole case, my lord. In any case, my lord, I have to be rejected from participating in the tender pension. First, my lord, I have been prevented from the participating in the tender by not accepting my processing fee, not accepting my EFD, my lord. And another, my lord, rejection is, as of course, this has not been communicated. What they are saying is, no, on 3rd July 2025, your bid documents has been rejected by this communication letter. Madam, there is a date for the scrutiny of tender documents, technical bid, financial bid. Lordship, at the very beginning, I have pointed out, it was my submission that double bid system, madam. Madam, what happened? Double bid system means technical bid as well as financial bid, madam. Lordship has seen technical bid on 15 July 2025, but the financial bid will be notified later on, madam. Madam. Correct, madam. Yes. They themselves are saying, madam. Yes. You have manufactured, you have done without coming in the office, madam. Yes. Now, madam, just for again, madam, just to continue, madam, just to clarify one aspect, madam. Again, madam, may I take your lordship to the same affidavit filed by the respondent number 4. Madam, it says data process. Board has to be constituted, madam. Board who will, madam, scrutinize the, madam, the page number, madam, 131, madam, of same affidavit filed by the respondent number 4. It was constituted by the page number 131. Yes. Respondent number 4 affidavit. 131. Madam, same office, executive engineer, Yamsa PWD division. It was constituted on 14 July 2025, madam. A board member, madam, office order. Madam, I'm reading the partition. A board member has been constituted for opening of e-tender papers on 15 July 2025 at 10:30 hours. So and so, in the office of the madam, superintending engineer, allocated for the work, so and so, so and so. Madam, who are the members of the board? It is given, madam. Executive engineer, person number 1, serial number 1, chairman. He himself is the madam. He himself is the chairman. And madam, altogether, board consisting of madam 11 members.
Yes.
Madam, they have what they has to do is, madam, they will scrutinize the they will scrutinize the tender documents submitted by the bidders on technical bid. If any bidders or the tenderer suffers from any infirmities, they are the authorized persons to declare being non-responsible. But lordship has already seen who has constituted this board at that relevant point of time. The executive engineer was not available, madam. This has been constituted by the madam signature. Madam, may kindly see the signature, madam. I'm madam again on page number 131, madam. This has been executive engineer, madam. Not disputing, madam. Disputing is premature rejection, madam. They have not enforced. Correct. Section 3 is, madam, condition of the contract. And this extract 108 is the extracted copy, madam, of the same terms and conditions. But the rest are not, madam, irrelevant. Therefore, they might have, madam, enclosed this particular clause. So it's just to demonstrate, this is the ground for which the, madam, the rejection has been done. Madam. What? Yes, madam. Yes, madam. Is the part of the correct. Correct. That we are not disputing. Yes. Correct, madam. What we are disputing is, madam, what we are disputing is, you have rejected my tender bid documents even on or before extended, that is 5th July 2025. Even after extended 10th July 2000. My rejection has been done with
Signature on
correct,
the-
madam.
Got your point.
Yes. And madam, madam, without having no option, as Lordship has already seen, we filed an FIR before the concerned police station. The concerned police station, they took cognizance of our case. Lordship will again find my
In your petition.
yes, again I'm coming to read my read petition, madam, page number 76, annexure 11, madam. This notice has been issued to the respondent number 4, who has played, madam, entire game. Page number 76, madam. This is the executive in city so and so, madam, by name, madam. This is to inform you that a complaint has been received on 6/7/2025 at PS from city so and so to the effect that as per tender process published by number so and so dated 30th July to June 2025 for the work so and so. They personally visited the executive engineer office on, madam, 3rd July 2025 and 4th July 2025, remaining present from 9 a.m. 4 p.m. to submit their documents. During this period, their tender and the relevant documents were received by the subordinate officials of the executive engineer office, but due to continuous absence of the executive engineer from the office, they could not proceed further with the tender process, which deliberate misconduct and abuse of the official positions and the criminal breach of trust by the public servant, knowingly disobeys the law with intent to cause injury and framing incorrect record or acting to cause the loss and the mischief, causing damage to their legal rights and business interests. The investigation is being carried out by the undersigned. It is revealed that there are reasonable grounds to question you to ascertain facts and circumstances. Hence, you are hereby informed to appear before the undersigned on 12 June, so and so. They have appeared. Now they are following the case, and that will be best answered by the other respondents, madam. But somehow case has been registered. This is Yopsa PS case number, madam. Number just above, madam. Yopsa PS case number 50. 2025.
Okay.
Now, madam, officer in charge, again, madam, another, madam, it's just under process, madam. Better should not be doing the officer, madam, the officer in charge by registration of the case, madam. But this is the only, madam, that the commercial transaction is to be done within the department, madam. But they have acted, madam, beyond their jurisdiction. They acted, madam, the serious, madam, infirmities. Then, my lord,
Okay, so there's a request to say for safe custody of.
yes, page number 77, my lord. Having knowing the, my lord, the ASW, my lord, well, we were apprehending that our tender documents will be tempered. That will be, my lord, the mishandle. So therefore, my lord, we made the notice of the executive intendant, ASW, my lord, who is just subordinate to the executive engineer. Now, my lord, he has made a request to the, my lord, the officer concerned for taking the same custody, my lord. And then,
Tender documents, but not the original.
not the original, my lord. Only the documents, my lord, submitted by the other respondent. My lord, they were apprehending there since we have been prevented from submitting the tender documents. And that tender original documents of the other submitted by the other, that could be, my lord, taken away or, my lord, somehow, my lord, there could be success of the law and order. Therefore, this precaution has been taken by the respondent department, and they asked the concerned police stations to take the, my lord, it was in the, my lord, office of the executive engineer. So therefore, the office, they apprehending themselves that we'll do something, my lord, untoward such incident. So just to prevent that aspect, he made a request to the officer in charge, please kindly take entire documents in safe custody. That was the, my lord, the whole story. And, my lord, again, page number 78 is the, my lord, intimation so and so that has been done by the, my lord, additional deputy commissioner. Even, my lord, that matter went to the additional administration side, even went to the, my lord, went to the police of police.
So what happened to the case?
My lord,
So what's happened? This case is also pending. So the outcome, what's going to happen?
my
You're
lord,
going to
now,
investigate it.
now, my lord, as per their contention,
Oh,
the, my lord, as stipulated in the terms and condition of the tender, they have opened the tender technical bid on 15th, my lord. On 15th, and as per the affidavit filed by the respondent number 4, they have opened and they recommended one of the, my lord, the floorship again very used.
private respondent.
No, no private respondent. Just only recommendation, madam. That has not been yet finalized. Not finalized. Only recommendation in favor of, madam. Just for a moment, may I take your lordships to the again page number, madam? Madam, just for a moment, madam.
Mhm.
Affidavit filed by the respondent number 4, page number, madam. 123, madam. 134. Sorry, 134. Only two, madam, this record, as per this record. 134, madam. Page number 133, affidavit filed by the respondent number 4. And the serial number, it is also not. But it is visible in their copy or not in my copy, madam. And visible, but some portion are missing in copy. Madam, name of the contractor just below, madam. In follow-up, madam, just the name of contractor, madam. MST Enterprises, madam. And HB so and so. What I intended to point out is A, madam, opening of technical bid. Madam, opening of the technical bid, date and time, madam, in first cover. Date and time at which technical bid were due to be opened. Madam, it was on 5th July 2025 at 10:30 hours. And madam, second, date and time which the technical bid were actually opened, madam, on 15th. Madam, may kindly again recall when my tech bid was rejected. It was on 3rd July 2025. madam. Therefore, madam, my rejection is premature. We have not been allowed to participate. Whereas you have gone to the date fixed on which the technical bid has to be opened on 15th. And madam, clause A, lordship has already seen. Next page, page number 135, madam. B, page number 135, madam. B portion, madam. Opening of financial bid, madam. Not notified, madam. Yes, madam. So meaning there, madam, not notified. And just again, madam, may I take your lordships to page number 138, madam. no minutes of the board of meeting, nothing has been incorporated in the affidavit filed by the, by board respondent. When it was held, home recommendation, normally what happened, board proceedings, it has to be recorded everything, and that things has to be brought on record, and that has to be filed along with this affidavit. Therefore, the affidavit, the records of the this case will be again required. Yes, and another just just 135. Correct. Yes, sir. As per their record, rest have been prevented, madam. These are the their own Susan firms. They are intended to award these works to this particular firm. Correct, madam. And just for just to clarify that aspect again, madam. Just to more clarify more, madam, page number 138, madam. Recommendation, madam. Two only, madam. And that has been done by the executive engineer by himself, madam. There is no board proceeding. There was nothing. Madam, just this has been taken into consideration by the executive engineer by himself. But madam, this has been recommended for, madam, but not yet finalized as of now. So therefore, madam, record is very important. Madam, why my bid has been rejected? Madam, I have not at all, madam, submitted my original documents, even earnest. Can the department process, madam, without processing fee? Can department process the keep on going for, madam, the scrutiny of my tender documents, even without, madam, accepting my earnest money deposit? That is the, madam, whole.
Accepted because he was not present, isn't it?
Yes, madam. So therefore, madam, the record will be called for, and in the meantime, madam,
There's already an interim order
yes, ma'am.
that will continue,
Yes,
isn't it? It appears that the documents are required. Records.
much of it.
During the tender, he was rejected straight away because he's a class two conductor. That's the thing. But the tender was just class one.
Just to clarify that question. I am class one registered contractor, one AML. No, it is specifically mentioned. In class one A, one double A, within bracket, madam, yes. Building and all. Yes. Yes, yes. I'm qualified.
Anyway, so you're saying that he could be unqualified. Could be, he's not saying he's unqualified, could be. So, yeah, I think this is the main thing. Doctor is the petition. Verify after verification.
lordship come to page 147, my lord. If they complies with the section clause 26 and section 3, my lord, consequence will be like this. My lord. The one for my lord, HP Enterprises, it complied with my lord clause 26, my lord, and see the my lord object made by the executive agent. Document found correct. Authorized person may enable processing here to 147, my lord. Yes, my letter of authorization of the firm who qualified, my lord. And down below, my lord, this is the observation of executive engineer. He checked and found correct everything, my lord. So authorized, my lord, directed to process, my lord, processing B and AFD. After verifying the document, only, my lord, executive engineer will make this sort of observation or remark to the down people, my lord, so that they can process, my lord, other tender. Similarly, my lord, base, my lord, my lord, 36, 30 June 2025. Then you lost in the you lost may kindly come to page 148, madam. This is the case of the petitioner. Top, madam, you notice find, madam, MS Badri, right? Down below, madam, this is the observation made by the executive engineer who received. Forwarded to the executive engineer in order to limited for verify and further purpose this. So it is wrong to say that this case was never processed.
The rejection part, again, what's this?
No, no, no. It's a question of rejection pass. Let us not put the cart before horse. So, my lord, this is that, my lord, 57, my lord. Yes, madam. My lord, there may be then something wrong. My lord. There may be mistake in the debt. No doubt about that. I'm not, my lord, saying anything about that. There could be human error is possible. My lord. But what is no, no. Now, what is matter of fact is that you have not submitted. You have this your submission that your case was never processed, which is not correct. Exactly that one exactly one. Now, another, my lord, page 140, 149, my lord. This is the same, my lord. The rejection of another form. My lord. This form also, my lord, did not comply with the clause 26, my lord. So his case was also not recommended for further, my lord, process, my lord. Your lordship say the another form who succeeded, my lord, complied with the section 20, clause 26, my lord. Lordship may kindly see the observation made by the executive, my lord. My lord, these are the dates, my, which is very important. Why I'm saying, my lord. Lordship sees all that, my lord. Either this is 2 or 3, my lord. On top, you lordship by 2/7/2025. Down below, you have, yes, correct. That authorized person may receive processing fee and AFD. So after that verification, verified by the executive engineer, will ask the downgrade people, my lord, accepting processing fees and EFD. Then only, my lord, he can upload his entire document in the portal, not before that, my lord. And these are the prerequisites in the terms and conditions. If you are agreed, why you have not challenged the terms and conditions? after rejection only, you are saying that these clause 8 and 5 are inserted so that this will qualify, this will make me qualify from the competition bidding market. My lord, now he cannot turn back after participating. Now he cannot say, madam, I did not participate. Once you try,
Here is what, Katana of decision, where in Bharat it has been stated. Bharat is stated, terms and conditions cannot be challenged by the Bharat. The terms and condition is the Bharat, the main of the Bharat, the tethering of the. But
you have not submitted.
Bharat, before Bharat, no, Bharat, we cannot, Bharat. No, we have not participated. And we cannot participate to the. Predetermined. Bharat not remain present in the office. Yes, I pointed out. Well, even Malad of apprehending the terms and conditions cannot be challenged. It is up to the domain of the state respondent Malad tendering authority. So therefore, even then I tried to participate, but my ground of rejection, if Lordship will use the time and again for then impute rejection. Yes, Malad, ground of rejection is something different, Malad. And we have not been, Malad, is there any, I'm asking myself, if there in terms and conditions stipulated under contract documents, then such rejection could be done prior to the technical fee. Everything.
Sorry for interruption.
Rejection can be done only on technical bid manner when it is open. Unless it is not open manner, how the matter of the is with law?
Yes, my lord, I'm so sorry to, my lord, then, my lord, would be mother financial on the part of the other side to understand, my lord, terms and conditions of the NIT. Now, my lord, section 3 and clause 26 categorically says, my lord, to processing fee, EMD, before that, you have to produce certain document, my lord. Now, my brother said rightly, my lord, they cannot challenge the terms and conditions, but that is the terms and condition. You have accepted and you try to submit with the Xerox copy, my lord, which we have denied, my lord. Now, what we can do, my lord, when the terms and conditions says, my lord, even we cannot even from the terms. We cannot accept your, my lord, Xerox copy. Yes. Then, my lord, the terms and condition is very clear, my lord. My lord, my friend is also reporting event, my lord.
Section 3, that.
No, no. Clause 3, my lord, milestone date for the tender, my lord. My lord, he's a class 1A, double A contractor. And he's a seasonal contract, he knows what is the terms and conditions. And he's categorically says, my lord, physical sanction of earnest money deposit, earnest money, then tender fee and other document. Other document we don't by clause. And all this. Now, my friend is saying, my lord, that these are the sole document to submit the tender document. Oh, before submission of entire document, tender document, we have given you almost 14 days time. Because submission of documents of tender documents are from 1/7/2025. The bid submission ends that is 14/7/2025. Gossip come base 32.
Yes.
My lord. Now, what my friend is trying to say, my lord, is clause 8 is negative of this. My lord, this is very much part of the terms and conditions. He said, man, he cannot challenge. If you can't challenge, you have to complain. Within this period, you have to submit the original document, which you have failed to do that. Now you are starting back and saying that these clauses are not suitable for, it is suitable for others. Same way, my lord. The another, my lord, that is National Competitive Board bidding, my lord, clause 5. Same, my lord, EMD and original documents. Find it, my lord. It says, my original documents, my lord. Why my brother, my lord, I'm not particular, the Badri right, fail to understand what is original. And this has been clearly spelled out in clause 26. So knowing all these things, my lord, they fail to submit, my lord, what we can, no other alternative but to reject his law for further process. Suppose if we accept, will other will be left out, my lord? They'll appeal to lordship. Look, they have violated their own terms and conditions. They have accepted this, which we cannot do. We cannot allow. It is the only reason, my lord, that we have not accepted. So, so far, my lord, allegation against the engineer, although my brother will be answering to that, but as a, he being my official, my lord. Now, the ethical allegation is there, my lord. Third, fourth, fifth. Now, this executive engineering deliberately remain absent. Because of it, absent, my lord, he is, my lord, what document will be processed, mother, which is wrong. Now, on that day, now this executive engineer, he was on field verification. My lord, we have 20 photograph also, my lord. So my brother is from that side, I think he can try to locate this photograph.
We are not disputing.
So admitted, my lord.
Facts remain the same, my lord. They remain absent from the office. We cannot go to the man of the field wherever
No. So,
executive engineer goes.
so you cannot blame, my lord, without any much evidence that he is a habitual of, my lord, remaining absent. On that day, third, fourth, my lord, he was on field verification report, my lord, that is not disputed. If the lordship come to my lord government affidavit, we have said so, my lord. Filed by the page, my lord, should be 114, my lord. 114 is it the photograph, my lord, down below the possible. Yeah, my lord. Absent, my lord, means what, my lord? My lord, but absent means, my lord, not attending the official duty, my lord. Was on official duty, my lord. Yes, my lord. He may say, my lord, he was not present in the office. He can say that. He cannot say that he remained absent from the office. My lord. This, now, my lord, coming to, my lord, this police report. My lord. Yes, lodged, my lord, police complaint, my lord, police, my lord, the engineer. Then let us see his written statement. The lordship may kindly come to page 126. That, my lord, not disputed, or not disputed. What is important, my lord, we also create with meeting not disputed, and due process, my lord. Due process and norm have been followed since that of issue of but while allegation have been leveled against my office, and there has been attempt to create by order issued by either my D has been put under pressure particularly on the day of fifth, where he was not allowed to leave the office till 7 p.m. My office could not have filed any police complaint against the troublemaker. However, in the larger interest of this matter, I refrained from the doing so and also repeated my aid to had the pre-bid meeting on pay. I have engaged in this fight and queries within and leaders as well. Sir, I have input all the documents for exclusion. So, my lord, the allegation that he remained absent delivered on third board pay, my lord, this is the reply given to the police washing. Now, what is most important, my lord? My friend was helping with two engineers, my lord. Right, my lord? Then on this day, executive engineer remained absent because of that. My lord. And you lord may kindly come this statement, this person before the police, my lord. Lord may kindly come to 128, my lord. But why these, my lord, documents was rejected? They refer to clause 26. You not remember? Yes, sir. 26, they have to produce the only document, my lord. Aadhaar card, PAN card, everything. Then because you know, paragraph 6. 6. As part of the pre-bid meeting was completed, was on so and so, but they said that around 11, 12, representative of both Badri Rai, Upeni, and Pinya Yamto enterprises, Kali Yamcha, the present petitioner, the Captain Yamcha, and so, came to the office and started making unnecessary further allegation and pressure. However, I, along with my senior officer, were able to exit the office premises for lunch. Snatch when we came back to the office for completing the official works related to the pre-bid meeting for the above mentioned NIT. Same group again came back to the office and started levying allegation. So and so was allowed to leave the office, but I was. This is very important, madam, because they are happy on their certificate. I was forcefully arrested inside the office premises by the representative of both the parties, and they started making demand that unless the executive engineer come to the office, I won't be released. However, it is said that he was on site visit and the query inspection to other leaders who were found eligible till that time. The same was also clearly communicated to the Kali Yamcha and others who were 7 to 8 p.m. I was made to stay in office beyond my will and was made to sign. Very important, my lord. Document which my brother was harping, my lord. The J has certified that my executive engineer is remained absent, my lord. This is the answer, my lord. I was made to sign, issue some document relating NIT against my will. This is exactly the statement given to the policeman. The same JE, my lord, certificate which is issued under duress or as compelled by the petitioner. Now his person is intelligent. Now he's telling the truth, man. I've been compelled to sign it. Now, my lord, now let us see the police person, my lord. Yeah, Gadi, my lord, possibly is your turn. I page 129, I being examined city working in court, it took me to the Yamcha PWT Western Structure that I have not the process also. And I think I was present in all legal process, video and photo. Everything also be available that I was present in all patient Yamcha. On 3rd July, I had done, I had gone on got maybe for. Yes, ma'am.
It was on duty.
Yes.
Now it's for something. I have a meeting, report meeting also.
My
So
lord.
we continue.
No, continue. my lord.
How long?
My lord, I'll be summing up.
Huh.
My lord. Now, my lord, the person who could not comply with the terms and conditions, my lord, he asking for, my lord, blaming his own mistake to others. My lord, the documents and other things, my lord, I have demonstrated. My lord, document which he produced, my lord, admitted that it was a Xerox copy, not the original document, my lord, in continuity with my lord, clause 6 and section 3, my lord. That is the reason, my lord, this standard was
No,
not
we
proceeded
didn't.
further, and there is nothing wrong in that. The technical bid is open, my lord, even because of my lord, not to proceed further, my lord. Even my lord, financial bid is almost done, my lord. Just, my lord, to issue, my lord, declaration of destruction. That is what they can. And now this being, my lord, the construction of road, my lord. Now this is the only season left on, my lord. Hardly 3 months. Now greater public interest demands, my lord. The private interest, my lord, should not be harmed because of his one mistake, my lord. He failed to comply with terms and conditions. This level is
Just one point. Madam, okay. Yeah.
Because
In the meantime, madam, NCR may be called, madam, record may be called.
report to what?
So, madam, the board proceeding, so, madam, other, madam, the correspondence, madam, this is premature, madam, there is no, as I pointed out, there is no terms and conditions under the.
Let him
Yes,
finish.
yes.
Let him-
Madam, in the meantime, madam, if it can be produced tomorrow also, madam.
for what purpose?
Madam,
Are you-
purpose is,
are-
as I have pointed out,
Madam, are
there
you-
is no terms and condition under which, madam, the clause, my tender can be rejected prematurely.
My lord, clause 26, my lord, clause 26, section 3.
It's not dates. So let's see, because the date you said must have been mistaken.
Yes.
My lord,
Uh,
my brain is saying, my lord, under which, my lord, section or grounds, my lord.
because it's not, the original was not produced, is it?
My lord,
Yes.
clause
Yes.
26 is very clear.
And I'll
Section
produce my
3.
original document,
Now what to do? You have not submitted.
which you have not at all refused to receive, which you have refused to receive, which you have not at all received.
I produced but refused to receive.
Yes.
No, no. My lord, not.
No, madam, this is not disputed.
So which can be clear from the.
Madam, I have enclosed,
From the documents, you're saying this will be clear.
yes.
So let me know first.
I'm sorry, my lord.
You're saying from the documents, what documents are there?
My lord, we are not possessing his original document, my lord. It's possessed by him, my lord. Then what document will produce, my lord?
Well, I-
Other documents, my lord.
But I have enclosed the copy, photocopy. But original copy has to be received by them, then has to be written by them till the process of the mother, the entire process.
Keep content, my lord. Representative with respect to my-
Yeah, the standing count.
Not-
Okay. Uh,
I will.
No, my lord, because I still see there.
On Monday, madam. In the meantime. Tuesday, madam. Or other
No, but because I lost my colleague.
matter may be kept
Yes,
partner.
I lost my colleague, taken note, my lord. Delay will take, my lord, project. So post escalation will be there. But are you ready to?
what to do? See,
What delay, my lord?
there is going to be some delay anyway,
My lord,
but the sport has to attend some conference. It has to.
Monday you lost it free.
Monday also.
Tuesday, my lord. Tuesday.
Tuesday, maybe Tuesday, but the sport will be, that is when. Bring that. Not be possible. To.
Otherwise, matter is very issue, very short matter. Whether he has complied with this clause 26 on the.
It's time.
It takes time, madam.
Yeah. Already one time. So it will be only on Tuesday. We have 1 day of hearing.
Malad, no more, my lord. Because I don't have any further submission. My brother will submit, my lord. Then it need be applied. That's all. Earlier,
I have just one thing to consider next day. I'm
maybe, my lord.
carrying
Then,
home. I have other things.
then you not see. Tuesday, my lord, we'll try, my lord. Tuesday.
Sit from part her on a Monday.
My lord.
And then we fix it. If we can fix it on Monday, can be heard by.
What monthly?
I will not agree to that, but shift in options are, my lord, completely.
So a lot of this thing, time
That-
has been,
Then
one-
you lot
one
will be coming back on Monday. Perhaps, the lot will be checking court on Tuesday, my lord.
Tuesday, but the judgment can take 3-4 months.
Well, no, I'm not worried about the judge.
So-
I'm worried about the disposal of the case, Malala.
Ah,
That is
so-
why-
No, 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 no.
No,
Then
that
that's
would
a
not.
matter. Then that's. So.
That what the paper.
Then-
The matter.
then-
This month. itself.
Then,
On
your lordship is inclined to release the matter. Then your lordship can modify the interim order. But your lordship may
cannot-
say, madam, no, that's the matter.
Yes.
Yes, then your lordship may kindly fix before the justice Kanda.
That's what.
Yes, madam. Yes, court number 3 is sitting, madam.
Tomorrow. I'll release it from being partner.
Yes.
And then we'll list it tomorrow. Then we have to be placed before there is. Because
Yes. Fair enough.
And then you have expressed great urgency in the matter. But
Tomorrow, then, now also you lordship to pass the order, madam. Releasing the
no. We leave it at that. Because there's urgency in the matter. Not partnered. So now you have all your points. When you submit again tomorrow, you
Yes. Some reply has been.
can,
Yes.
what, refine your submission. That it's always there after once, third, yes.
Yes.
Any other matter?
Yes. Item,
Yes. Oh,
item number 15.
order.
I will pray for allowing me to take justice steps upon respondent number 8 and 9. We have tried many times by register depots, but most of the time it was seen as a awaited.
Okay, heard Mr. So learned counsel for the petitioner who submits that he may be allowed to take steps for service of notice upon respondent
Respondent number
number
9
9,
and 8 and 9.
8 and 9 through dusty mode, since there is no return of ED card from the said respondent number 8 and 9 till date. The court is court find it appropriate to allow the hearing counsel for the petitioner to take steps for service of notice upon respondents number 8 and 9 through dusty mode, and affidavit to the effect to be filed accordingly. This after 3 weeks.
Much of it.
Item number 16.
Yes, Mala, the respondent number 5, 3, and 11 is yet to file it. Therefore, I may be able to take a first step upon respondent number 11.
But it's good. Sorry, Council. The petitioner who submits that since return of person service report on respondent number 9.
11.
Oh, 11 is still awaited. He may be allowed to take fresh steps for service of notice on respondent number 11.
Madam, I'm appearing respondent number 7 to 10. You have already filed.
The learning council for the petitioner is to take fresh steps for issue of notice on respondent number 2. Registered post namely within 3 working days, which are provided. Then Mr. Council for respondents.
7 to 10.
7 to 10 submits that they have already filed the counter affidavit. While Mr. Running now, he submits that.
I have filed affidavit on behalf of respondent 1, 2, 4, and 6.
But
On behalf of respondent 3 and 5, I need some time.
1,
1, 2, 4, and 6.
6, and say for further than 5.
3 and 5.
Never. What is the matter of the three?
Item number 19.
My lord, due to paucity of the time, my lord, I back to item number 26. This may be my lord takes on 29. I have taken consent from the my lord government. Item number 26 on the hearing.
When is- So let's say. Make it first week of complicated. With the consent of the other side. Or it's not, make it the first week of November.
Any other proposal? No.
Third.
Fine.
Third, 11.
Item number 19.
Respondent 5.
I'm filing 6.
Miss so and so that the council for the petition has chosen. So that the council for respondent number
3, 5, and 6.
3, 5, and 6. The learning council for the respondents update for further time. By date for cost stagnation. What is the matter after? How long will it take? 2 weeks.
Item number 20.
This is content, so you're going to follow him or new incumbent will be needed? Okay. Has to be that person. Okay. But Mr. Deepanak, planning council for petition of submits that. He may be allowed to take fresh steps for service of notice upon respondent number. Okay, upon the respondent that he has changed his current address. You have the book?
Item number 22.
It's regarding trustee service. Ending 8/2025. Honorable court have directed and allowed.
Trustee, so have
And
to
that
take,
is completed
so affidavit? Not
through
filed.
affidavit. I have submitted the affidavit on 29,
For respondents number 9 and 10,
respondent number 9.
not represented,
Not
let's see the affidavit. When was it? See,
I filed on 29 August. I have submitted before the registry. I filed with.
Okay, 9 and 10. I heard Mr. So-and-so, then it counsel for the petitioner who submits that he has served a notice on respondent's number 9 and 10. And that they can find it. The result of the affidavit filed by the petitioner dated. No date, 29 August 2025, it is seen that notice was received by respondent number 10 on 27/08/2025. We received on, this is
Same,
respondent
the same
number
day.
10.
On 27, both the respondent they received.
Okay, notice was received on 27.
27 August.
8/2020. Yeah, but not just the things to come. Have you filed a counter? Then on it, by the time, file, the counter affidavit, now, this number, so, section. Well, have you filed? Okay. Three of the above, let's see, after 3 weeks.
March of
Item number 23.
The topics matter, huh?
Well, for the petitioner, I like to notice.
Oh, very good. Why?
It's I have an instruction. Right.
Not the person who has the harm. We heard Mr. Not for the petitioner. Submits that like to withdraw the consent. As a fact. If you have the book. See number 666.
I would like to play the one matter, item number 1, which I played them to be fixed on 27. But on 27, I have some personal difficulties. So this motion matter, item number 1, maybe fixed on 29. Next week.
21. Next week.
Wednesday.
Make note of that.
March of